The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. Good afternoon. Welcome to the Court of Appeals. We have 4 cases up for argument this afternoon. We're going to start out with the case of Oriella Torres versus Garland. We will hear from the appellant first.
Thank you, Your Honor. Erica Hashimoto, court-appointed amicus in support of Mr. Oriella Torres. With the court's permission, Helen Moon, a third-year law student in the appellate litigation clinic at Georgetown Law Center, will present argument in support of amicus.
Thank you.
May it please the court. This court should grant the petition for review because the agency arbitrarily disregarded critical and legally significant evidence establishing that Mr. Oriella Torres met his burdens for asylum and other immigration relief. As to the past persecution analysis of the asylum claim, Mr. Oriella Torres' credible testimony establishes that the harm he suffered when viewed in the cumulative established a death threat constituting past persecution. But the agency failed to apply the cumulative effects of harm analysis.
Can I ask you a question? You said that his credible testimony established death threats. Is that
Yes,
right?
Your Honor.
So as I understood it, it looked to me as though what the IJ credited was your client's testimony at his hearing, because the testimony at the hearing was consistent. There were some credibility questions, but the IJ thought that what he said at the hearing was consistent and credible, but at the hearing, he didn't mention anything about death threats. So how do we know that there are credible death threats on this record?
2 things, Your Honor. First, the IJ deemed credible his testimony, and on page 61 of the administrative record, the IJ noted that his credibility determination rested not just on the demeanor and responsiveness to questions, but the internal consistency of testimony, including written or oral testimony. And so we ask this court to properly consider both the hearing testimony as well as the additional statements in the application as elaboration of his testimony. And second—
Can I just as a matter of common sense, just a death threat seems like a huge thing to omit during one's oral testimony. I mean, of all the details that would jump to mind, I would think when recounting a story like this, the part with the death threat, what is the explanation for why that didn't come up at the hearing?
Mr. Oriella Torres did credibly testify as to being beaten in the face with a gun during that hearing, and that is at least an implicit death threat. It is more explicit and severe than what this court has held that the brandishing of a knife was at least an implicit death threat. Here, the gun that was used is more dangerous than a knife, and it was used not just to brandish it and intimidate Mr. Oriella Torres, but it was used to actually inflict physical harm against him. And so under this court's precedent, in the presence of 3 key ingredients, 1, which is at least this implicit death threat, 2, a repeated series of threats and attacks against Mr. Oriella Torres, and 3, increased severity of harm by the persecutors' knowledge of his whereabouts when they tracked him down at his workplace, later on his usual path home on a rarely traveled dirt road, and then later still at his home. Viewing all of those things in the record in the cumulative, Mr. Oriella Torres has satisfied past persecution. This was not an isolated incident, but it was a systematic series of threats and escalating physical harm against Mr. Oriella Torres, and he feared for his life so much that he had to abandon his children and his partner and siblings in El Salvador in order to flee And the third attack, in which the FMLN persecutors came to Mr. Orellana Torres's home armed with weapons and surrounded his house in search of him, appears nowhere in the IJ's opinion nor the BIA's opinion.
But counsel, again, the fact that the people who came to his house were armed also doesn't appear in his testimony, or I think in any of his sort of paper declarations. Don't those details about how the people at the house were armed and threatening, doesn't that come from the affidavit of one of the supporters whose statement actually contradicted your client's statement in material respects?
Two things, Your Honor. First, Mr. Orellana Torres did testify during his hearing that they returned for a third time and circled his home. And second, the affidavit statements, the IJ considered those statements. The IJ considered the inconsistencies and considered Mr. Orellana Torres's explanation as to those inconsistencies during the hearing, and still deemed credible his testimony. And so the fact that that third attack occurred is uncontested. And although it occurred just days after Mr. Orellana Torres fled El Salvador, it remains relevant to the past persecution analysis because it provides vital context to understanding the meaning of the FMLN's threats when they returned to beat him, when they made additional threats against him. It showed that they had not fully realized their threats and attacks against him during that second attack, as the government contends. Their threats were not empty, and there was more to come.
What do you mean? The threats in general? What are the threats to him? What was the basis of those threats?
The threats were expressly conditioned on Mr. Orellana Torres's vote for the FMLN. And
this is in the year 2014, is that correct?
That's correct, Your Honor.
And was it for him to vote in a particular way or just to vote?
So during the first encounter, the FMLN expressly conditioned their threat suffer the consequences on his vote for the FMLN's presidential candidate. And the agency erred in determining that he was not involved politically and disregarded compelling circumstantial evidence establishing that his persecution occurred on account of his affirmative political opinion when he refused to vote for the FMLN presidential candidate.
So is the allegation, or at least the threat, by individuals who ostensibly may have been employed or paid by the FMLN to harass this person or to get him to vote?
Yes, Your Honor, it was because he refused to vote for the FMLN candidate that the persecution occurred. And the government itself concedes that at least the first encounter was on account of Mr. Orellana Torres's political opinion.
So let me tell you where I'm going with this. We're talking about election in 2014. And then there's another election that happened in 2019, of which I think is pretty easy. It's another country, and we know generally what happened. It's not of the record. That's the interesting thing here. We can take that notice, but it's not in the record. And typically we don't do things if it's not a record. We have to judge the board based upon what's in the record. But in 2019, that election changed completely. And the question that I'm asking is, if that threat is by the FMLN and they're no longer in power, what would be the basis for a gang to continue something with no purpose to it here?
So as to Mr. Orellana Torres' fear of future persecution, the fact that the 2019 elections occurred would be relevant to that. But even if that were part of the record, it would have to go back to the agency to consider if circumstances in El Salvador and the political power of the FMLN had changed such that Mr. Orellana Torres no longer has a reasonable fear of future persecution.
But let me ask also, do you accept that if there is information for which is of the judicial notice prerogative, I'm not saying it does appear this could be, that has happened that would abate a threat that maybe the record would have shown did exist in 2014, 16 and on. In other words, if you had someone who specifically say a particular government was harassing, but the government is overthrown, you have a totally different government, the system is different. Do you think that's a reason to send it back for the board to consider whether this is information that they should consider and if it has any impact in terms of their determination?
Yes, Your Honor, because Mr. Orellana Torres has established through his credible testimony that he suffered past persecution, he is entitled to a presumption of a well-founded fear, and the government would have to rebut that presumption. And in order to do so, that would have to go down to the agency. But I do note that the government did not raise this issue in the briefs, and so I would be happy to provide supplemental briefing on this issue.
I ask maybe a related question that's a few steps back. We often think about agencies under Chenery as requiring them to provide the rationale. And so if we come in on the back end, even with judicial notice, that typically we don't provide a basis that the agency itself didn't provide. Yet in the immigration context, we also have cases that say that we apply a harmless error doctrine, which seems inconsistent with Chenery's sort of underlying principle. Could we do that? I mean, strip away some of the complexity that you pointed out. If we were to find that there was evidence, judicial notice or otherwise, that would suggest a finding was harmless, but on a basis that was not suggested by the BIA, are we allowed to do that?
Your Honor, I would respectfully push back because the agency disregarded credible and legally significant evidence that was probative and supported Mr. Orellana Torres's claims for asylum. And so the error is not harmless.
Right, but imagine that. So imagine I agree with, it's just hypothetically, I agree with you that they ignored credible and important evidence. But I also found that there is other evidence that was also ignored that, supported the ultimate conclusion. Right? Can I rely on that other evidence? Or am I bound by or limited to, is maybe a better way of saying it, the rationale that the BIA or the agency provided?
In this case, I don't think so, Your Honor, because under this court's precedent, it is an abuse of discretion for the agency to arbitrarily disregard probative evidence without providing clear and cogent reasons for discounting.
It's an error, but the question is, we also say it can be a harmless error. And what I'm trying to say is, if I found it was a harmless error based on other evidence, can we as a court reach that decision given that we're reviewing an agency's decision?
I believe the court can find that an error was harmless, but this would have to be remanded to the agency to properly consider that evidence in the first instance. And if I may address the agency's reliance on unfounded speculation, the BIA failed to provide reasoned consideration of Mr. Orellana Torres's claim on administrative appeal that the IJ was biased by the fact that he had family members living in the United States. It only repeated the claim, but provided no analysis, nor did it definitively conclude as to the claim. And its general conclusion that it found no clear error of fact in the IJ's decisions was so cursory that it deprives this court of the opportunity to meaningfully review the claim. And so,
Counsel, can I just push back on that a little bit? I understood, I think your argument here today, the way you have sort of framed the bias claim is that sort of impermissible speculation kind of tainted the IJ's fact finding. But I understood the BIA to be making kind of independent factual findings that you just can't show persecution on this record. And if that's so, if that's the right reading of the BIA's opinion, then doesn't that, this isn't the technical term, but doesn't that kind of clean up any problem at the IJ level? because we're reviewing the BIA's opinion, and the BIA didn't engage in any impermissible speculation, and it made its own factual findings. So if they're supported by substantial evidence, isn't that the end of it?
I don't believe so, Your Honor, because the BIA did acknowledge the claim, but did not provide any analysis as to
But
the
I
claim.
think it did when it said, we find that, there wasn't, the conduct here wasn't sufficiently severe to rise to the level of persecution, and the government wasn't unable or unwilling to control, and there was no nexus. That does address, it does address your concern. If the IJ's fact finding may have been tainted by impermissible speculation, so the BIA went ahead and did it again without the speculation.
Two things, Your Honor. First, this court can review both the BIA and the IJ's opinions because the BIA explicitly affirmed and adopted and then supplemented the IJ's reasoning.
And adopted it. I feel, I'm not sure about that. We review final agency action, and I'm not sure why the BIA opinion isn't the final agency action here, because it doesn't expressly incorporate any part of the IJ's reasoning. It's not one of those opinions where they say, for the reasons given by the IJ, we affirm.
That's correct, Your Honor, but it does explicitly agree with the IJ's findings. For example, it says explicitly that we agree with the IJ's finding as to past persecution and well-founded fear. And second, we ask this court to consider the IJ's opinion. The IJ indulged in unfounded speculation.
Well, in that regard, does it matter that the BIA opinion was a single member opinion?
Yes, Your Honor. I believe that single member BIA opinions don't warrant the same amount of deference. But we ask this court to consider the IJ's unfounded speculation.
What do you mean they're not entitled to the same amount of deference? They're not entitled under Chevron deference, but that's in another case. What's the support for the idea that a single member BIA decision is not entitled to the same degree of deference in this very case? Right? The case law we have, at least that I'm familiar with, does suggest single member BIA decisions are not entitled to deference in the legal interpretation realm. But in the case that we have, they get the same degree of deference, no?
Your Honor, I see my time has expired. May I briefly answer the question?
With Judge Wynn's.
You may.
Thank you.
Thank you. Here, the BIA's opinion was a single member decision, and it provided no reasoned explanation of that claim on administrative appeal as to the IJ speculation. And so that provides this court with an independent basis to grant the petition and remand that's independent of the merits of the asylum claim. And I will address further questions on rebuttal. We ask this court to grant the petition. Thank you.
Thank you. We'll hear from the appellee, Mr. Tennyson.
Good morning. May it please the court, or afternoon. May it please the court. Robert Tennyson for the government. This panel should dismiss or deny the petition for review because it lacks the agency's decision is supported by substantial evidence, both with regard to asylum, withholding of removal, and protection under the Torture Convention. With regard to asylum and withholding, there's no past persecution in this case, as Judge Harris pointed out. The threats or the statements of the petitioner in his testimony related only to were statements that, or the attackers, the FMLN partisans used were, "You will suffer the consequences." In the first encounter, that's very vague and inspecific. And then in the second encounter, assuming that it is still the FMLN that is acting and that they are punishing him for the acts, they responded, "You will face the consequences," and they hit him on the face with the gun. That doesn't amount to a death threat. That amounts to a threat of harm at best, a threat of assault. which is neither so systematic or extreme to constitute past persecution. Moving on.
Is that a factual question? Like whether what happened is an implicit death threat?
Right.
Is that a factual decision that the IJ and BIA are making?
Good question. I think it is an application of the standard to the circumstances. I think the immigration judge provided sort of the factual findings here. And then what the board did is they applied that standard, right, for persecution or for past.
No, but the standard being, I mean, not sure I'm following that, because some things can be explicit and some things can be implicit, right? And there's not a legal standard for that, right? And that's sort of a factual question.
That is
right?
a factual determination.
That
Correct.
I can tell you to stop talking, or I can raise my hand, sort of implicit that you're going to stop talking when I do that. But it's just sort of a factual question, right? I could just be waving at you, right? And depending on your perception, you might view it as a stop talking, and you might view it as a great to see you, or a variety of other, possible meanings. And so I guess what I'm trying to get at is not the application of the standard, but whether what happened here was an implicit death threat, which is your colleague's argument. That strikes me as a factual question.
That is a factual question, Your Honor.
Okay. And you're taking the next step of whether, if it's an implicit something, whether that meets the standard. Meeting the standard is the legal question, but whether what happened amounts to an implicit threat of death in particular, that's a factual question we review for substantial evidence. And okay.
Absolutely.
Can I ask you a question? If it weren't an implicit threat, what's the threat? I mean, as I understand it, in the first encounter, he's told, you better vote for the FMLN or there will be consequences. And then he doesn't. And then he's punished on the petitioner's theory for that. But I'm not understanding what the future threat would be. I mean, he already did the thing he's in trouble for.
That is correct, Your Honor. He did the thing he's in trouble for, that he was told you'll suffer the consequences. And when he was hit on the face, he was told you will face the consequences.
These are the consequences.
So it seems that you have the threat and you have the completion of the threat. And that seems to tell us, at most, that tells us what the threat was. If it was a threat, right? I mean, if you look at the first instance in the abstract, I said, if I came to you and said,
well, you don't dispute the first one is a threat, right? Vote for this guy or you'll suffer the consequences. It's not a death threat, maybe. I understand that. But, if you don't do X, you will suffer consequences. That strikes me as a threat.
Or don't do that or you'll suffer consequences. Remember, this is in a context of a political election. It's possible that they're saying, vote for them or you'll suffer consequences. The gangs will continue, the truce will continue unabated, right? Because at this point, there's the gang truce that's in place. Or you will not have, the economic benefits that occur to your agricultural production. Whatever it is, you can think of a wide variety of consequences someone might be suffering. So it may very well be that kind of encounter. But given the circumstance of what happens later, I think the government's more than willing to say that this looks more like a threat. I mean, it certainly looks more like a threat than it looks like just sort of some generalized proposition or assertion that, hey, there's going to, if you vote, elections have consequences, right? So insofar as past persecution goes, it looks like if we read that as a threat and we know what happens at the back end, that the petitioner gets punched on the face after being told now you'll face the consequences. We know what this whole entity is with regard to past persecution, and that it's not an implicit death threat. It's an implicit threat of harm. And if it's an implicit threat of harm, along with the harm that he faced, that's neither so extreme nor systematic that it would constitute past persecution.
So what do we make of the statements he made to the asylum officer regarding the fact that if he reported this to the police, they would kill him?
Right. There are these subsequent statements. There are these or previous statements to the asylum officer, as you say, Your Honor. But it looks like the immigration judge is focusing mainly on that testimony when he discusses it. For example, in his account of the petitioner's testimony, in his account of the petitioner's statements of what happened, seems to be very closely cordoned to what he said. And so in that regard, I think we rely, the factual findings that the specific factual findings the immigration judge is making come from that testimony.
So would it boasted the past persecution and claim the statements that these men came to his house after he fled?
So that's not a past persecution issue. That's after he's fled, right? He's not suffered them.
That's why I said boasted the claim of it.
Right. What, Your Honor?
Boasted it.
Yes. There's some sense in which you can look at that to sort of try and get a better handle on what the previous, what the persecutors may have been thinking. There are certain instances in which you can look at subsequent facts that will give you that will inform sort of your understanding of what your persecutors are up to, correct? But here, all we have from the testimony is a statement that the persecutors come to his house, they circle it, that's all we know. We don't know what they do, we don't know what they say, because we don't have that in his testimony.
So is that how you square away the IJA saying that, well, it's credible, his story is credible regarding the attack by the FMLN, but that he was being subject to a random attack by hooligans? How can both of those findings be true?
I think that's that finding that he was attacked by random hooligans. One, I don't think that the board upheld that part. I think the board very clearly, one, focused on past persecution. And then when they said it wasn't on account of, their statements seemed to indicate that second encounter may not have been on account of his political opinion. And that's because they did not know that the petitioner did not know how they would have known he didn't vote. And he couldn't identify them as being specifically from the FMLN. So as a result, the inference is, while that first one where they say vote or you'll suffer the consequences, we've got that. I think the board and the agency could reasonably have come to the conclusion, and that's all you need for substantial evidence, that second event was not premised on political opinion. I don't want to lean too heavily on that because it is sort of I think it rides the line. But at the same time, we don't even have to get to that because here we don't have this rising to the level of persecution, given the testimony that was given by the petitioner.
So are you arguing that the first attack was based on a political opinion, but not the second one?
Right. So we've got two different groups of people, right? The first attack is two people. They come and there is some sort of, they obviously identify themselves as FMLN, right? And say, go vote for FMLN, so for the consequences. The second attack, we don't have that. The second attack, he says, three people, he was getting on a bus, three people came out, said, now you will suffer the consequences, which would seem to, if an immigration judge or the board wanted to latch onto that and say, that's the same group, that's the FMLN.
And the consequences are basically the same. You got two different groups.
Right.
That makes it a little less to the side of random, does it?
It does, Your Honor. It absolutely does. I completely agree with you, but substantial evidence doesn't require it, right? So that if a reasonable judge could say, yeah, that leans in favor of this being FMLN partisans who are following up on the previous threat or the previous statement, yes, definitely. But the immigration judge could look at those other factors out there, right? The fact that he couldn't identify who, how they would have known he didn't vote, or that he doesn't, he states, one, with regard to gangs, do you have any idea that they are related gangs? And ultimately he says, absolutely not. Or he doesn't say, let me qualify that. He says no. And he says these are unidentified individuals. They don't say anything about the FMLN when they attack it. So you've got evidence on both sides. And you're right. The statement, now you will face the consequences, does seem to lean in favor of this second event having been the follow-on for the first event, which was based on persecution. But substantial evidence allows the immigration judge to say, well, okay, you've got that, but these other features of your narrative allow me to draw the conclusion, or I think the reasonable inference from all of this is that that second incident was just some kind of random violence.
Even though they both discussed the same consequences, one before the election and one after.
I agree. I would agree with you on it.
The question is, they say the word consequences.
Right. They say the word consequences.
But it's not necessarily, that's the challenge, is we don't really know whether they're the same consequences or not. You don't need to reach that issue though, right?
We really don't. We can just rely on the past persecution issue, on the past persecution finding.
Well, on that, you did say the men coming to the house. It seems like the case law says that's relevant for the boasting of the past persecution. And if it's so, there's some statement that the IJ didn't really develop that at the hearing. Our case law requires him to do so.
I think that in certain circumstances it's relevant. I don't think it's relevant here because if assuming that the first and second incidents are both motivated by, and remember, the people who come to the house, we don't know who they are. The assumption is they're the people who hit him the second time.
Maintain they're just another random group that decide to come to his house.
I'm saying it's potentially right, Your Honor. I think it's probably that second group that's coming to his house, but we don't know all we know is they circled the house, they left. We don't know what they were doing, why they were there.
Testimony, at least statements from neighbors and others about these men and what they were doing.
Right. And the immigration judge didn't give those credence because they conflicted with his own statements. Remember, all of those statements had to do with what MS-18 was, or MS-13 was doing at the time, right? Both his sister's statement and the two other individuals all say that he was threatened by MS-13, and he expressly disavows this in his own testimony. And so the immigration judge has something to choose from here. He can just sort of disregard those statements.
Could the immigration judge have concluded that the second, in theory, given that there was some suggestion that there was both a voting problem and a gang problem, that it was just as likely that the consequences for the second incident were gang related and not voting related, and the third one were just as likely to be gang related or voting related? And so that's part of the problem, that the only one that we know he was targeted, and we know in the first instance it was a voting problem, but there's at least some evidence in the record that that he had done something that aroused the ire of the gang, whether true or not. There's at least some suggestion of that. And what we can't do with either the second or the third is establish whether they were gang or voting related.
I think that is correct. The earlier gang encounter occurred about 6 years before, but right, we can't tell what that second event is. And again, I would say that third event only goes to sort of how we would understand the motives. It isn't an incident of persecution. It's something different. We don't read that to be an incident of past persecution. It's valuable for us to figure out. It might be valuable for us to figure out what the motives of the persecutors were doing in the past, but it's not an incident of past persecution itself. So
in other words, what you mean by that is if they showed up on the third instance and said, "Where's that dirty non-voter?" then we could use that to draw the inference that the second attack was also a voter attack.
We could do that, right, Your Honor. But it wouldn't. But it still would.
Let me ask you in that regard. It's not just an isolated MS-13 event we're talking about here. As I understood, there was evidence that the FNLN and other political parties, they were using gangs to do this, paying them money. I don't know what that meant. It's an interesting situation. I guess the purpose was to get people to vote. I don't know if it was to vote for a particular one. Probably the desire was a particular one, but to get them to vote. His problem was he didn't vote at all. And so you got these members, and what is this other thing that supposed to have raised the ire of a gang that caused the second? What was that?
With the second incident?
Yeah. What was it that he had done that made the gang want to come after him?
There was no second incident. What would he have done? Well, they were mad at him because I believe there was an incident about 6 to 8 years previous where the gangs wanted to attack a friend of his, and he somehow interceded.
So we have an incident 6 to 8 years, and then they show up after this first instance and basically saying you're going to suffer the consequences of what? Of something 6 to 8 years ago? Or when we know there's evidence in the record that the gang is being used to harass or get people to vote. I mean, those little, they call them the little political parties. There's a tremendous history here. And it's interesting, the history of it. When you hear FMLN, you think of, well, these must be terrorist groups. Well, these are people who are representing the poor peasants and stuff who become the power, but then they get in power. And I don't know, maybe I'm not going to judge a country in terms of how its government runs, but they want to stay in power. They get in power. They're in there for one election, got another one. I don't know how they do it, but they all of a sudden just take over. And so now they begin to use these gangs to get out the vote. Well, to get them to do it, and then the individual here says, I'm not going to vote. I don't know anything about voting. He doesn't vote. So they get him for not voting. He didn't do anything. He just, on the first instance, we're pretty clear on that. Then the second time it comes around, and you're saying it's because of something 6 to 8 years ago when they say consequences? Does that sound, I'm thinking, if you can pull this inference, it's a stretch in my opinion, but it could be, but I'm not feeling that one. If it had been something that happened maybe a year or something earlier, or something more explicit, but we do know that gangs were being used to harass or to deal with people who had not voted. And these people were in power, and it was significant to them.
So let me go through 3 things here. The first thing I want to go through is point out that particular piece of evidence that I think you're looking at, which is a statement by a member of the Barrio 18 gang, right, which is a separate gang from MS-13. The Barrio 18 gang, which
is that a gang involved here? Is that gang involved here?
No, Your Honor.
Don't confuse me.
No, Your Honor, they're not involved. This is an that anyone talks about a game is MS-13, or at least I don't believe that's the case. So
this is the evidence in the record.
This is the evidence in the record.
Gangs are used to get out the vote,
right? And the way in which they get out the vote, and it's expressly in the individual's testimony, which, by the way, is stated to be unverified, and this is a blog report of a particular trial that's going on. So the statement's unverified, but what he says, how the gangs got out their vote?
Well, who says?
He says.
Who's he? Who's he?
The gang member, the Barrio 18 member.
There's the
Barrio 18 member says
they are using gangs to get out the vote.
The way in which they do it is for the gang to have their members go out and vote, to have their families go out and vote, to have their, I guess I want to call them collaborators go out and vote. So they're encouraging them to go out and vote, and then to get in the way of the arena voters. So to undermine the vote of the other party. There's no go and impress FMLN individuals into the vote.
Do you really believe that? I mean, let's talk straight here. You're saying they're asking a gang member to go and get out the vote, and they just do what grandma and grandpa would do and kind of says, well, you ought not do it, and you go here. Or do you think they go to an MS-13 member and says, get out the vote? They have a means of doing it, but it's probably not what you're talking about.
That's all that we've got in the record. So we can't sort of jump and say, there's some statement in here with regard to the gangs.
I don't understand about the whole gang thing, because my understanding of what happened in this case, and tell me if I'm wrong, is that there were these affidavits in support of the petitioner.
Right.
two affidavits saying he has been threatened by gang members, his fears of gang members, he's fleeing gang members. That's what's going on here. And so he, at his hearing, is required to say, this has nothing to do with gang members, and those men who attacked me were not gang members. So whether or not this political party is using gang members, I mean, the only testimony we had in this case from the petitioner himself is these were not gang members.
Exactly, Your Honor.
Okay.
He says it multiple times. He disavows the involvement of the gangs.
Okay. Can I ask you an entirely different question?
Absolutely, Your Honor.
It's about the torture prong, which I guess is not really the focus of the case here. But the amicus does argue that the BIA used the wrong standard of review in reviewing the torture finding, that it applied clear error review, which it seems to have when we held in Cruz Quintanilla, that it's at least partly a mixed question of law and fact, and it should be reviewed de novo. And you don't respond to this in your brief, and maybe this goes to Judge Richardson's question about harmless error, but shouldn't we just remand and have the BIA apply the right standard?
Excellent question, Your Honor. I would say that this is probably a harmless error case. I mean, I don't think you need to send it back simply because there wasn't any evidence here that would amount of torture, right? The immigration judge said, I don't find a shred of evidence that the individual was tortured here. And if you look at, sort of all of the country conditions reports, none of them speak about the FMLN engaging in torture. None of them, they talk about it as being party in charge. And his statements are purely about having been punched on that one occasion. So I think under a harmless error standard, there would be no reason to go back. Let me circle back briefly to the question about, can we look outside the record, since that was asked previously, to look for harmless error? I think that would be, I can understand looking in the harmless error analysis at the record itself and saying, look, this record here does not give us any purchase. I mean, this record here gives us purchase for a harmless error determination. That is, the facts in this record, even if we were to send it back, there are these other things that in the record would prevent us from, from upholding the agency's decision. I suspect it would be problematic, particularly because 1252, let's see, I guess it would be D2, requires the determinations of cases to be on the record. And if the harmless error determination is sort of generated outside of the record, it strikes me as something one, it's focusing on one minor thing, and maybe there's more evidence out there that the board would need to address. So it seems to me that's, if you end up having to look outside of the record to determine whether there's harmless error, that's probably something the board needs to do. But I think that in the record here, that would establish harmless error in this case.
All right, thank you very much.
Thank you.
Judge, you have anything? You have brief rebuttal.
Thank you, Your Honor. First, the government contends that Ms. Oriana Torres has not met past persecution here, but even if this was not a death threat, the cumulative effects of the harm Ms. Oriana Torres suffered established past persecution because of the presence of the three key factors, which is one, the repeated and persistent series of threats and attacks against him, including the third attack. Second, at least an implicit death threat in the beating with the gun. And third, the increased severity of harm by the persecutor's ability to track down his whereabouts. And although the government contends that the threat ended with the second attack, the third attack clearly shows and paints a clear picture of the FMLN's both intent and ability to follow up and continue escalating their attacks against him.
That's a question I have about the escalation point. I don't see that. Like, how do we know that they're escalating? Let's assume that we're looking at the part where they circle the house. Where's the escalation in that?
It shows that it was a continuation of their previous threats and attacks, and that they were not done at the second attack. In fact, at the end of the second attack, they said again that they would come back to make him face the consequences and that they would kill him if he reported to the police. And he didn't report to the police, but they still returned, which shows the escalation.
Why does that show escalation? And I don't mean to be, let me tell you my thinking. Assuming we're looking at this third attack because it sort of gives color to the first two. It seems like what it might, perhaps the more ready inference at least would be they're coming back. But I don't understand why we would assume from the fact that they're back, that this time they're back to do something different. Wouldn't the more ready inference be they're back to do the same thing?
They sent more guns with more men, and this time they came to his house. But even if they were going to physically beat him, no, but even if that was not an intent to kill him, we don't know what would have happened because he had fled just days prior. Their physical attack, under the cumulative effects of harm analysis, that shows that this was a systematic attack against him and that this was not
doesn't have to be escalating. Your argument, this notion of escalation, sufficient if it stays flat. And I don't mean to trivialize this harm at all. So your argument would be it's sufficient.
Yes, that it's a continuation of their threat, and that the continuation was on the basis of his political opinion, because it's legal error to require that Mr. Orellana Torres knew exactly how they knew he didn't vote. They knew he didn't vote, and he even confirmed to them that he did not vote for the FMLN. And so given his persecutors' repetition of the same threat, suffer the consequences which they had made during the first attack and repeated during the second attack, it naturally follows that the second attack was also on account of political opinion. The agency also disregarded circumstantial evidence of the timing, that they followed up post-election, and that this was a highly polarized electoral climate. The FMLN only won re-election by a razor-thin margin of 50.1% of the vote. And so that establishes that the persecution was on account of his political opinion. And the identity of the persecutors does not matter, whether it was the MS-13 acting on behalf of the FMLN to further the party's interests. The persecution came from a major political party using its governmental power. And in the alternative, Mr. Orellana Torres has shown that the Salvadoran government was unable or unwilling to protect him from his persecutors. And so we ask this court to grant the petition for review and remand to the agency to consider in the first place the evidence it disregarded, but at least on the independent basis of the BIA's lack of reasoned consideration of the speculation claim. Thank you.
Thank you. And I want to express on behalf of the court our appreciation to the Georgetown Law Center in the person of Mrs. Hashimoto and Ms. Munn for taking on this very difficult case. And we also thank you too, Mr. Tennyson, for your fine presentation. As you know, we traditionally do come down and greet you with a handshake, but that is a courtesy we dispense with in light of the greater risk of transmitting a virus to you. But who knows, we may come back when times are more normal. But thank you both for your presentations. We'll proceed to the next case.
Your Honor, my name is Valen Brand, counsel for appellant Hyla Nicholson.
Let's proceed.
The anti-kickback statute, any violation of the anti-kickback statute that results in a federal constitutes a district court agreed with that. However, it erred when it found that plaintiffs for Nicholson's allegations failed to meet the standard under 9B. The anti-kickback statute simply says that anybody who receives a remuneration knowingly and willingly to arrange for or receive or arranging for or to make recommendations for purchasing products paid by the government has violated the statute. In the complaint, plaintiff specifically pointed out that pursuant to an agreement, an illegal agreement that violated the anti-kickback statute between Medcom, that was owned by Jeff Turpin, and Rob Holloway, an independent sales contractor, as a result of their illegal compensation agreement where Holloway was paid based on the volume of sales into VA hospitals.
So I'm going to ask you to be very specific here, because I think this is a case, I could let you go on, but it wouldn't hit specifically as to what we ought to be addressing here.
Okay.
What, from my perspective, my colleagues may be different. And that is it. Pleading these kind of cases are very difficult. There's a particularity requirement on a 9B, and then you got Rule 8 implications. You can do the best you can do and probably not figure it out, but if it's conclusory, which an appellate court can come to that conclusion, it's not going to go nowhere. So, when you're looking at this specifically, why don't you tell me what is your best argument that this amended complaint adequately alleged the inducement element of the anti-kickback statute violation?
Well, the Rob Holloway was induced by Jeff Turpin to go and promote products that where Holloway was incentivized based on the amount of utilization paid for by the government. According to this case law in this circuit.
Is that evidence, or is that a fact, or is that a conclusion?
Well, that is the allegation. And specifically, the allegation said.
An allegation typically, notice, is enough in most claims, but the way these cases come out, and I'm just saying, I say I agree with it, but it is the way it is, the law. It has to be, you have to have something very particular here in order to be able to sustain that element.
Well, the theory is that the more products that were sold, the more the government had to pay for those products. That was in violation of that was the motivation behind the sales agreement. And under US v. Mallory, the circuit had already addressed this specific issue where it said that it is illegal to make payments to individuals for the purposes of federal health care programs paying for those products or services. And so consistent with that, the complaint spelled out that a similar arrangement was made between Holloway and Jeff Turpin. And as a result—
How did he do it? How did Holloway arrange for or recommend that the doctors purchase these products?
Well,
how was it done? That's what you mean by particularity. You can say he did it, but it's just a few, some words, something you got to put in there to say how he did it.
He went face to face. As the complaint mentioned, this was a buy and bill arrangement where the physicians engaged with the representatives on a face-to-face basis who were there to promote the utilization of those products. And as a result of that promotion, as well as the availability of the product provided, it was utilized on or about November 2016 on a specific patient.
So, counsel, you said a couple of times just then that Holloway was promoting the products.
Correct.
I'm sorry, I didn't see that in your complaint. And I thought that's what the district court thought was missing. The part where Holloway is being induced by the commission to actually push these Integra products, to recommend them. And the district court thought you hadn't alleged that in your complaint.
Yes, and if the court is to note that proposed amended complaint, it did specifically use the word promote to promote those products.
That seems like a huge problem that it didn't use the word promote or recommend. It didn't sort of close the final loop, which is that he's being incentivized. I don't like that word, but he has an incentive in the form of this commission payment to do something, but we don't really know what the thing is. The last step of this scheme, this anti-kickback scheme, has to be, so when he goes to make his sales calls, he says, you guys should use Integra. Integra is what you should be using, and the complaint doesn't allege that.
Yes, and the complaint, the proposed amended complaint, I believe the arguments with respect to addressing the court's concern that the product could have been used just based on availability, I pointed out that we actually did state in the proposed amended complaint that Holloway promoted these products. It wasn't just that he made them available. And so construing the allegations as required in the light most favorable to the plaintiff, considering all the allegations that the whole purpose of this co-promotion between Integra and Medcom was to utilize these products. And in fact, there was a reference to the sales competitions, I believe, that spoke to the nature of the competition, which was to promote the products. And so that was why he was there. He also made it available, but that was just to point out that's how that particular claim got submitted pursuant to the legal compensation agreement, where Holloway was specifically promoting and providing these products under the buy and bill process.
So what may be missing there? You may have said promote and promotion, but you didn't tell how he promoted it. I mean, what were the specific facts? The promotion is the result. It's what happened. But how did he do it? I mean, did he? I don't know. I mean, what did he do? What were the facts to say he promoted it? Promoted is like a conclusion.
Okay.
So that's what I'm asking. And Judge Harris' question is great to that. And you did mention promote in that amended complaint, but that's all you did.
And Your Honor, in fact, if the term promotion and what went into what promotion entailed needed to be amplified, obviously, that's something that can be addressed. Futility is a different position taken by the court, but that's something that can be addressed through amplified facts. As you know, this complaint, basically there was only one attempted amended complaint. In addition, I don't believe the defendant specifically argued that the term promotion was conclusory or anything that pointed out that was the issue upon which it was resting the defense. But to the extent that it
Can
is.
I ask maybe a predecessor question here? We've talked a lot about the amended complaint.
Yes.
But the district court denied your request to do that. Can you tell me what information in the amended complaint was only learned by your client after the initial complaint was filed? I mean, part of the idea here is the court found bad faith, right? That what you can't do is file a skeleton complaint, get the judge to issue an order, and then put all the information that you knew before in the complaint. And it looks like when I read your amended complaint that most of the information was information that your client had before the first complaint was filed. And the point of this is I want to know what was the new information that was not known, and how do I know that it was new so as to find an abuse of discretion by the district court in finding that you withheld information that you already knew on the first time, such that we can even look at this amended complaint.
Okay. So as far as that point goes, Your Honor, the district court did make a finding that there was bad faith based on allegedly withholding the information. However, it's important to note what information was actually supplied. From plaintiff's perspective, most of it was immaterial because you had the addition of a first name, for example, of the sales representative.
I understand that, but what I'm asking is, what information did your client learn about this scheme after the first complaint was filed? I get that you think it's irrelevant, doesn't matter, but I'm asking sort of a specific factual record question. Is there something in the record that suggests to me that your client only learned certain facts after the first complaint? And if so, what?
I wouldn't say that he learned so much more. I would say that most of the complaint was directed at clarifying the court's confusion about what the scheme entailed. And so the scheme was identical. In both complaints, we alleged that Medcom, along with Integra, utilized sales representatives such that those representatives by Medcom were paid on a 1099 basis, which violated the statute. And as a result, false claims came from that. Both complaints said that.
Okay, so if I accept that idea, help me understand. So that suggests to me that the finding that you withheld information from the first complaint that you put in the second complaint, how can I then find that the district court abused its discretion in refusing to permit you to amend the complaint, 2 years later, based on information that you knew at the time, when the first complaint was subject to Rule 9's strictures?
Well, primarily because if looking at the court's actual language. The primary basis for the bad faith finding was completely wrong finding by the court. The court claimed that the theory changed. The theory never changed. And it was based on the fact that the first time there was an allegation that Integra utilized reps and Medcom employed these reps. The second time, to make it more clear to the court that it was Medcom that utilized the reps, he used the term utilization. But if you employ the reps to promote the products, you're clearly utilizing those reps. So the theory stayed the same. And the district court did not recognize that. So he thought that the theory.
And your point is that that's clear from the first complaint?
Yes, it is. And that was
But it depends. That conclusion depends upon it being clear to us from the first complaint, what you just said.
Well, I couldn't speak for the court. I'm not sure if I understand your question.
Okay. Okay. So that's one, and then I'll let my colleagues go ahead. Is there any other reason why you think we could find that the court abused its discretion in finding bad faith?
Well, based on the case law, there was basically no precedent that I could find to suggest that clarifying a complaint to address whatever alleged deficiencies existed on the front end, especially when you're talking about adding a first name, adding a specific VA location, and as opposed to saying the VA, the Durham VA, adding these that's the purpose of the amendment, to address the court's alleged, point out those deficiencies. And so, and you couple that with the fact that, like I mentioned before, our position is that the original complaint met the standard. But insofar as it didn't, it was just an attempt to clarify the court's confusion about what the actual complaint entailed, because according to the court, it said that it was implausible for Integra to have utilized, for Medcom to have utilized reps that were reimbursed, I believe, by Integra or something to that effect. And that was not the actual spirit of the claim. The reality was these two companies were co-promoting the same product. One was manufactured by Integra. The other one was simply sold by Medcom. And as a result, there was a dual incentive to promote the products. And so once the court misconstrued the theory, the amended complaint largely was made to address that, as well as add particulars with respect to 9B. But the theory remained the same. And so based on the circuit, the law in this circuit with respect to Mallory that was decided sometime last year, and United Airlines v. Grant that said that one of the critical questions is whether or not the scheme can be connected to the presentation of a false claim. Appellant clearly presented a scheme that was connected to the submission of a false claim. And so as a result, the district court erred when it held that the appellant did not meet the standard of 9B.
Okay, thank you very much. We'll hear from the appellee. Proceed.
May it please the court. Good afternoon, Your Honors. It's an honor to be here. Jeff Whitley here on behalf of the appellees, Jeff Turpin and Medcom Carolinas, Inc. Your Honors asked two of the most critical questions here. One is, which complaint should we be looking at? And two, where are the facts? What Relator presented to the district court in the first instance was a complaint that was long on conclusions and short on facts. And it was beyond that, it was, in the district court's words, incomprehensible. The scheme was incomprehensible based on what was pled. And that's due in large part to two critical omissions. One is that there are no allegations against the defendant, Medcom Carolinas, Inc. There are allegations against a non-defendant, non-existent entity, Medcom LLC. And then there are these duplicate.
Is it a just as a question, is there a Medcom LLC? Does that exist?
Your Honor, if it does, it is not related to
that's I don't mean, is there one everywhere? Not related to you.
Correct, Your Honor. So what the court was faced to look at is what are the allegations of this scheme of the commissions paid to contractors? And what the relator alleged was Medcom LLC, a non-existent, non-defendant entity, utilized 1099 reps to generate referrals for Medicare, Medicaid, a defendant, an entity that doesn't exist. But at the same time, alleges that Integra, relator's former employer, utilized 1099 non-employee reps to generate referrals in violation of the anti-kickback statute. So as between those two allegations, the fundamental basis for the scheme did not involve Medcom Carolinas, and there were these conclusory allegations as to Mr. Turpin with no explanation of what his role would be, no explanation of the relationship between Integra and Medcom Carolinas. And so the court was left with, well, what am I supposed to do with this? There's no allegation that connects these defendants to this payment to Mr. Holloway, who's not, described in any particular detail in the first complaint. And so the court gave ample basis to look at it, whether it was the basis of the claim that the relator set up as a representation, or whether it was the particularity with which he pled the who, what, when, where, and how of fraud, or whether it was just the plausibility of the scheme. Any one of those bases independently allowed the district court to say there's no there. He has not alleged either an underlying predicate anti-kickback statute violation, or even if we accept this notion that you can plead as to commission payments to contractors, and we accept that might result in a false claim, you still haven't alleged the
Can I ask this question? I'm trying to understand the paragraph 16 in the original complaint.
Yes,
in light of the district court's findings. And it says that these representatives, which I take to be the contractors, were paid by Mr. Turpin, and then separately, and which he can do, right, as long as it's a salary. There's nothing wrong with paying them. The question is, can he pay them based on volume? But then it says, and I assume meaning separate from the payment from Mr. Servin, they also received commissions, but it doesn't say from whom they received those commissions. Can I tell from this complaint if they were, assuming that it alleges that commissions were paid, who was paying those commissions?
I don't think you can, Your Honor. I think that's another part that was not necessarily as in detail discussed by the district court, but I think that's another problem with what he says is the compensation arrangement, particularly in the first complaint. Now, it has its problems in the amended complaint as well, but there's payment, there's the use of the term payment, there's use of the term commission, but there is no detail, and certainly no detail in a particular action to tell you this is what constituted the payment. This is what the service was for. This is what the commission was for. And critically, any of those payments was made for the purpose of inducing referrals to be made.
And then and I want you can go back. I think you said there were two questions. I think we're still on the first one, best I can tell. But can you, in order for us to consider the amended complaint, am I right to say we must first find the district court abused its discretion in finding bad faith in order to deny the amendment?
Absolutely, Your Honor.
Right. So if we found that abuse of discretion, then we could consider whether the amended complaint meets the standard.
Absolutely.
But short of that, we're only left with this initial paragraph 16, the one paragraph, not the 3-page.
Given our circuit's precedent, it is a deferential standard. And the only time that it is something beyond abuse of discretion is if the court decides that it needs to go to futility. So, for instance, if the district court had denied the motion to amend solely based on futility, this court has the opportunity to go straight to futility. But because there is a reasoned basis and under the deferential abuse of discretion, because there is a reasoned basis, this is not an instance where the district court just said, denied, I'm not giving you a reason. It is not where it is so arbitrary and capricious sort of on the record that he didn't make any considered determination as to why. But there is a step one to that analysis. That is, did the district court under the abuse of discretion standard abuse that discretion, and is so, I believe the standard is so clearly, apologize, Your Honor. is only a decision that could not have been reached by a reasonable jurist or what may be called fundamentally wrong, clearly unreasonable, arbitrary, or fanciful. That's what the court has to decide first, is the record citation and the district court's reasoning for saying after judgment, this amendment must be considered because we have no reason basis based on the record to support the finding of bad faith. And Your Honor, so just to get through, because I think to the extent we need to address the amended complaint, the district court reached its conclusion. There were not sufficient allegations that either plausibly spoke to the scheme as to these defendants, and then the district court gave a pretty detailed reasoning as to why there are not particularity allegations that are required by Rule 9b and which are particularly important in the context of False Claims Act cases. This is a quasi-criminal statute that has substantial penalties.
Why do you say quasi-criminal? Because I take the anti-kickback statute to be an actually criminal.
You're correct, Honor, perhaps a little loose in the language. Quasi-criminal is pulled directly from the Grant case. It's the way that this circuit has described it as quasi-criminal when it's describing essentially the civil application of the criminal statute.
Can I ask, and this is a little bit of a frolic detour, but you know this world better than I do. So I was shocked to learn that, and I want to make sure I understand this correctly. If a company selling a medical device holds a competition, and they say, we're going to give a Yeti cooler to the person who sells the most widgets. Does that violate the anti-kickback statute? Because remuneration can be in-kind remuneration, and it is based on the volume of sales. And so in that scenario, both the company and the salesman who accepted the Yeti cooler can go to jail?
Your Honor, it is an excellent question of which I wish I could give you an excellent answer. I can say that it is an evolving sort of body of case law as to how far that extends.
Well, but it's not, the statute's pretty clear, right? It says remuneration, right? So, everybody agrees that under the statute, regulations are different. I'm talking about under the statute, if you pay somebody a salary, that's remuneration for selling widgets, medical widgets, that violates the statute. Now, then the statute says, but the secretary can bless salary, but it doesn't bless, it seems to me, a Yeti cooler on account of the volume of sales.
Your extension to it is not just the payment. And that's part of the problem that Relator had here in his allegation. It is not just payment. You cannot say paid for that particular graft, and whether that payment was made as part of some illegal compensation structure that involved Mr. Turpin and Medcom Carolinas.
Do you agree that the state law claim dismissal should be without prejudice?
Your Honor, to that discretion to retain jurisdiction over this. To the extent it is based on anything else.
In other words, he didn't reach the merits of it, so there's no basis for him to dismiss it with prejudice.
I think given this court's case law and precedent, that would be a reasoned decision to come to, Your Honor. There are merits-based reasons why that claim should be dismissed.
Let me ask you on these cases, we increasingly like we're getting, I don't know why I'm getting more of these False Claims Act cases, but these cases are different from the run-of-the-mill file a complaint, civil type action, whether it's quasi-criminal or whatever. Rule 9 has added this particularity requirement. We have Iqbal and Twombly that come involved in it. So there are different kind of cases from what I see the normal complaints. A complaint of this sort, as your counsel on the other side has alluded to, typically is read in a very liberal fashion in which you can infer certain things, and it survives 12b-6. But this complaint does not even make it past dismissal on 12b-6 basis, because from your perspective, Rule 9 requires particularity. And it seems as though the case law is headed in that direction. And I guess what I'm at is almost to the point you probably ought to put in this thing or or do what it mean to get promotion, go into the details ad nauseum, say too much. It sounds like to me to get these cases past the 12B6, then you're going to run into summary judgment down the road, of course, but at least you might be able to survive that aspect of it. And I'm just wondering, you do view these cases as being different than many of the regular civil cases that we deal with in terms of the pleading requirement. For whatever reasons, that's where we are.
Your Honor, I wholeheartedly agree with that. In the stratification of least to most allegations, these sit amongst the top, and there's good reason for that. There's at least two really good reasons. One is what I alluded to earlier, which the circuit talked about in the Grant case, which is it's the gravity of the liability that's at issue. You were talking about.
Yeah, but the oddity of that, right? And we're way out of, the frolic and detour land here, but if you get indicted on an anti-kickback violation, the indictment has to include darn near nothing, right? And yet to get sued civilly. So you're just talking about the gravity of the penalty. But, if you get indicted, it doesn't have to include anything. But, to Judge Wynn's point, if you get sued civilly, I mean, you got to dot every I and cross every T.
Well, and I think the other reason for that, Your Honor, which is the other point I was going to address, is that it's a whistleblower statute, right? So the promise of pot at the end of the rainbow for the whistleblower who has a valid claim is that they're coming in with substantial pre-discovery knowledge, because otherwise it's a free-for-all. In the healthcare industry, it's every person who, it's see something, say something, gone wild, without an understanding of what's going on in the healthcare industry. It requires the relator to come in and say, I personally was involved in it, or I can give you examples of claims that I know to be false. And the fallout from not having that is the burden on this court's docket, but also the liability that we talked about.
We probably could go round and round. Judge Richardson brings up a great point. He being a former prosecutor, I hadn't thought about that. He's exactly right. You can be sent to jail quicker on this thing than you can to get money from it. There's a balancing thing here, and that's not our job as judges. We'll just do our job and follow the rules here. But every now and then we do like to express our frustration. You have anything you'd like to add?
No, Your Honor, other than to just reiterate Judge Richardson's appropriate point, which is the amended complaint didn't fix the issues. The district court got it right, and it said, let's assume that he added the contractor's first name, and he added the place of the Durham, the VA facility was actually in Durham. He added a few details that, as we pointed out, he should have had at the beginning, should have been there in the first instance. It didn't fix the fundamental issue. Where are the allegations that payment from these defendants were made to induce Mr. Holloway to make this product to get a referral of a patient for use of this product? And the injection of additional allegations such as the buy and bill model actually really cuts against the plausibility, even though there's more details in the amended complaint. The traditional conception of what buy and bill means, as opposed to one-off uses, is that the provider or the doctor buys in bulk medicine, they pay affirmatively out, and then as those supplies or medications are used, they're then billed. So the allegation that this was made as a buy and bill type model for the VA suggests to me that there was a sale to the VA writ large for no referral at all, and then there are uses as patients come in. Well, that's not an inducement of individual patients. That is the supplying of product that will be used at some future date. Now, whether or not that's what relator meant, I can't tell. We can't tell from the amended complaint. But what's important about that is the fact that you can't tell says that he has not provided the type of detail that Rule 9b does require. But to Judge Richardson's point, we don't need to get there, because there is ample evidence in the record that the district court made a reasoned determination that both the late coming allegations, the shifting allegations, and the essentially putting in allegations through the briefing and the violations of the local rules were sufficient to find bad faith. And the court can stop right there. The district court did not abuse its discretion, and this court should affirm both the dismissal of the original complaint and affirm the denial of the motion to amend.
Thank you, Mr. Pitt. Mr. Bland, you have a few minutes in rebuttal.
Yes, Your Honor. I'd just like to add that despite the arguments by defendants, plaintiff or Mr. Nicholson plainly alleged that it was Medcom sales representative Rob Holloway was paid by the owner Jeff Turpin on a 1099 basis to promote products, including Integra's IDRT. And as an example, pursuant to that scheme, Rob Holloway submitted a claim for payment on or about November 2016 to Dr. Phillips for an Integra dermal replacement therapy graft for use on patient TW at the VA. As a result, the claim was ultimately paid to Integra by an agent of the processing department of the VA through VA care benefits in excess of $3,000 during the same month. Based on the case law in this circuit, as well as that I pointed to in Grubbs, to require any more at the pleading stage would surpass what's necessary to win at trial. And that's not what the result that this court should agree to. The fact of the matter is, I understood the court's earlier question about language about promoting and amplifying what the promotion entailed, but these were sales representatives. And they were there and paid based on the utilization of these products. Looking at the plain language of the anti-kickback statute, that is illegal. The arrangement was illegal. In Mallory, this court said that sales representatives who are compensated for recommending a health care service like the HDR or single X text to physicians, they use that as an example of illegality. The payments don't have to be made to the doctors. The payments were made to the reps, and those were illegal. And as a result of that interaction, those products were used on a patient at the VA by Dr. Phillips. The claim was tendered. Based on the buy and bill process, the claim was tendered by Rob Holloway to the physician, who was an officer of the VA. He's the one using the product. And then it's paid for through purchasing. So if we know that it was paid for, we know where it was used, we know what patient it was used on, we know all of the parties, the particularity is there. And the notion that it was some nomenclature issue of Medcom Carolinas versus Medcom LLC corrected that. And yes, the district court was confused as to who Rob Holloway worked for, perhaps, which is why I thought the allegation shifted. Defendants were never confused. They capitalized on the court's confusion. Rob Holloway always worked for Medcom. The theory was identical, and that was the primary purpose for which the court found bad faith. Now, it did add something along the lines of withholding facts. But what were those facts that were withheld? Again, the specific VA location, the first name of the representative. Based on the case law, that was not material. I believe the particular date maybe, but I believe the complaint, the original complaint included November 2016. So those facts were not material changes. The theory was identical. So yes, the court made a ruling that plaintiff engaged in bad faith, but that was completely erroneous. And based on the facts of this case, that the standard to show that the court abused its discretion was met. Beyond that, Nicholson would also allege that state claims should not be dismissed with prejudice. The false record presentation was sufficient to meet 9B as well. And the court should reinstate these claims because the original complaint was sufficient and the proposed amended complaint was definitely sufficient to meet the requirements of 9B based on the case law of this circuit of United Airlines v. Grant, as well as the decision in Mallory, which basically said these type of arrangements are illegal.
Thank you, Mr. Bland, Mr. Whitley. And as you know, and I said earlier, we normally would come down and shake your hands. It's a tradition that we hold dear, is unique to the Fourth Circuit. We won't do so here because of, for obvious reasons, the virus. We look forward to the time when we can. So thank you for being here today. You guys.
Thank you.
We good? lawyer for this case.
May it please the court. I'm Richard Monahan with Bordis and Bordis on behalf of the relator Taylor in this case. We submit that the district court below misapplied the standards of review for Rule 12b6 motions to dismiss, as well as a Rule 56 motion for summary judgment. We also believe that the district court below failed to consider that fraud and conspiracy claims are typically proven by circumstantial evidence and reasonable inferences to be drawn from that evidence. Rarely speaking, do defendants ever admit to engaging in fraud, whether orally or in written documents, or engaging in a conspiracy to commit such fraud. We also believe that the district court failed to consider the corporations have the imputed knowledge as well as the collective knowledge of their officers, agents, and employees. And lastly, we believe the court failed to consider that members of a conspiracy are responsible for the acts of one another also. This case is brought under the False Claims Act. In this case, the district court, in analyzing the claims at issue, we believe, failed to construe the allegations of the complaint as true, and also failed to give the realtor all reasonable inferences which may be drawn from such allegations. In this case, the first claim was an implied false certification claim, similar to what the United States Supreme Court dealt with in Escobar and what this court dealt with in the Triple Canopy case. Specifically in this case, in 2004, Dr. Thomas Mayer formed best practices in Virginia. Camden Clark Hospital in Parkersburg, West Virginia, contacted him about providing physicians and mid-level providers to their ER. At that time, Dr. Mayer found out.
Can I interrupt you? Sorry, just because I don't have time to get to it. Can you pivot and you can come back to this claim for a minute? I want to talk to you about Dr. Perini for a minute. And these are sort of factual questions based on the record. So you allege in your complaint that he filled out this attending physician's box.
Yes.
And his testimony in deposition was that he denied filling it out. And so your allegation has been rebutted by his denial. Is there a material issue of fact on that point? So tell me why I can disregard his flat denial. He says, I didn't do it. Wasn't me.
Yes, well, because that's a credibility determination, which is normally for the trier of fact to assess. We have alleged,
but you have to have evidence that goes against his claim, right? So he has an undisputed, or one might say, has an undisputed statement. Your allegation doesn't count, right?
Wow.
That he didn't do it. Wasn't me.
This court has case law, for instance, that acknowledges that a self-serving denial is not sufficient to defeat, or it's not sufficient to obtain summary judgment unless there is objective cooperative evidence in support of it. In this case, the defendants have not produced any evidence of anyone else that says they filled out that box.
Yeah, but his objective evidence is that when you look at the check marks, they're a different handwriting, right? So when you look at the check marks in the attending box, they're different than the check marks that he made below. That's what he said in his testimony. And frankly, when you look at it, they're different. So, you know, that's some evidence, objective evidence that corroborates his denial.
We would submit that just a mere check mark and saying it's different without handwriting experts coming in supporting that is not sufficiently corroborative to support that. Moreover, he He says that when he signed this document, he didn't mark anything in the attending physician box. He left it. It was completely blank when he saw it. He didn't mark anything in it. He put a signature on it, and then he marked down below there, template complete. And that was the check mark that should have sent it to billing. Well, we know from what's been produced in this case that that's not what this record shows. It shows the attending physician check being marked. It has a circle around the nurse practitioner, and then it has a section to go on to proceed about interviewing the patient, seeing the patient. Our expert, that we have an expert, David Forrester, who says in this case that in order to be billed for a physician, for instance, seeing a patient, you have to have a face-to-face encounter. He says that Dr. Kearney should have at least marked somewhere in that attending physician box that he did not see the patient.
There's nowhere for him to mark that, right? I mean, let me just maybe ask you a different way. Is there any other evidence that you would like for me to look at that you believe, other than the fact that when you get it in discovery, it includes a check mark that is contrary to his denial and the difference in the way the check marks look?
I would say I would ask Your Honor to consider two things.
That's what I'm trying to get at. Yep.
Yeah. I mean, one, any of us, when I sign a bunch of letters in a stack, my last signature looks nowhere close to my first signature. I'm just saying that the fact that the check marks look slightly different, I don't think is strong enough evidence to support that he did not sign the above ones. Moreover, this court has case law where doctors are committed or convicted of Medicare fraud for signing documents but leaving them blank, and then somebody else fills them in later. By signing that document without making sure that boxes that should have been checked and filled out were filled out correctly, he can be liable under the law for a crime, not just for civil liability.
But your whole point is that if he filled that box out, it was false. I mean, that doesn't make any sense to me, because the box is only if he saw the person and he didn't see him, so he would have to leave it blank.
Now, but our contention is the best practices of West Virginia and the parent corporations instructed everybody in this emergency room to sign off on these charts, regardless of whether they saw the patient or not.
And they did sign off on them, but not in the attending physician's box.
Only if you believe his testimony. And a reasonable inference for a jury.
But that's the evidence you've got that contradicts his testimony and the check marks.
And the law of this jurisdiction that notes that somebody can be convicted for signing a formal paper that's going to be submitted to the government for reimbursement and leaving things blank when they should be filled in properly.
So what's the false statement is the question.
Well, there's two. And if you want me, this particular one is an upcoding scheme, because a nurse practitioner, for instance.
I know we want to go there, but I'm saying, I'm following up from Judge Richardson's question. If the box is blank and he didn't see the patient and they're checked, but if he didn't see him, what's the false? What's false that he's alleged here? What's the false statement here?
Well, I mean, one, he could fill out in the box that he did not see patient, only reviewed the chart.
But there's no space for him to do that, right? You want him to put an appendix to it, right?
No, there is a line there that somebody could write, did not see patient.
Well, wouldn't it mean
only
the same
review
thing
chart
if you don't check a box saying you saw him? Doesn't that mean you didn't see him? If you didn't fill that box in, and I take it from your perspective, we ought to just take it that he did fill it in because the check is there and the signature's on.
Well, I mean, certainly, as I indicated before, that before marking that check template box, he should have filled out everything that needed filled out. And there are legal requirements for not doing so. But it also gets into the whole scheme of what we're contending that's being done here. And that is
what makes it interesting is that box you're referring to is actually encased in another little black box, sort of separate. And I'm thinking he signs this thing, it's down on this signature below, and then he checks temper. There's nothing that indicates that what he is signing is including what's in that black box, because he didn't see him, so he didn't sign that.
And that's according to him. But that's one reasonable inference, but it's not the only inference. I mean, that's
not an inference. That's actually direct evidence.
Well, his testimony.
I didn't do it.
Well, I know his testimony, though, but without other corroboration other than his testimony, I mean, there's been no evidence produced by anybody that anybody else filled that in or could have filled it in. The defendants, none of the parties on the defense side have produced any testimony saying, no, he didn't do it. This person did.
Yeah, but that's why the burden's yours, right? I get it's hard, right? I mean, I'm not disparaging that, but like, I agree. If he didn't do it, somebody did, but somebody did, like, doesn't work, particularly in a Rule 9 context when you got to plead it with particularity. And you've only alleged that he did it, best I can tell.
Well, I mean, I think we let the factual circumstances, particularity, knowledge, and those type of things can be pled generally. But he was granted summary judgment later on. The court actually denied the motion to dismiss for Judge Perney, and he was later ruled upon summary judgment where the court believed his testimony and didn't look at any of the other possibilities or what we believe were reasonable inferences in that regard. Now, but the claim is that they were telling all these doctors to review these charts, whether they saw the patients or not, so that they could be billed at the full physician rate. Rather than if a nurse practitioner did it, it'd be 85%. Dr. Perney himself testified, for instance, that best practices did not permit nurse practitioners to sign for billing purposes. He says, now if the nurse worked at urgent care and they went ahead and let them do the signature, they couldn't bill for the physician rate. Certainly that's an inference that he knew the importance of this.
They directed the physicians to sign those medical charts to obtain payments at a higher reimbursement than would otherwise be allowed. Where is the indicia of reliability as to that assertion?
Well, it's in the testimony. Anthony Kitchens was an employee of best practices that also was a medical director of the ER. He admits in his own affidavit that they were instructed to sign off on all the charts for billing purposes.
Counsel, can I ask you about that? Because I found both this chart thing and the testimony confusing. So Dr. Kitchens says we were told that doctors should sign them for billing purposes, but that's different from we should sign them so that they would be billed at the higher physician's rate. And it does seem like it says physician signature. A doctor is supposed to sign this thing, but that seems different, again, from saying the doctor was the attending. Those seem like two different things. They're set up differently on this form. That seemed to me to be the import of Dr. Kitchens' testimony, that we sign off on it, the whole thing, but that does not signify that we were actually the attending physician. Aren't those two different things?
They certainly can be, depending upon what their intent was and exactly what was said and what was told to these people.
Well, what have you, besides Dr. Kitchens' statement, which I think does not get you where you need to go, what else? I really don't understand this scheme. How is it supposed to work?
Well, because by signing off and either leaving it blank for somebody else to fill in the way they wanted to for billing purposes, or filling it out yourself, it enables Martin Gottlieb and Associates to then go ahead and bill at the full physician rate, which requires a face-to-face encounter with the physician. And
so you're saying as long as a doctor signs off where it says physician signature, but let's say the doctor signs off, but there's no indication that the doctor actually was the attending. That's enough to get it billed. The allegation in your complaint is so long as a doctor signs that line, even if it's clear he's not the attending, this thing's going to get billed at the physician's rate.
Certainly the attending box in this one was filled out with other things in.
Yeah, just imagine hypothetically it's not. This is the part of your complaint I don't understand. It's not clear to me where you're alleging how Gottlieb decides how to bill these things, and or where you're alleging that the whole thing turns on whether a doctor signs this line at the bottom that says physician signature.
I mean, it's based, obviously, of course, what happened in this case, when you look at what was submitted. I mean, for instance, Martin Gottlieb put in there's a couple other things in addition to the signature, but they put in a code to bill at the highest rate, which deals with the level of a high degree of severity for the patient's condition, which could cause a serious risk to life or physiological function. And then they also put in the Q6 modifier, for a locum tenens physician, a substitute physician. And with all that in there, Martin Gottlieb then went ahead and submitted the bill for a full physician rate, which is 100% of what could be charged under Medicare or Medicaid.
Which paragraph of the complaint alleges that it is the signature and not the attending note that Gottlieb relies on to bill it at the doctor rate?
I don't know that there is one paragraph that says just that by itself.
Okay. If it is, I want to see it. If not, I totally get it. But that's what I think I'm trying to maybe get a different version of what Judge Harris is trying to get to.
No, and I understand what you're saying. I mean, conceivably, if all that was done was the physician sign and nothing else was filled out in the attending physician box, is that something that certainly if Martin Gottlieb had not billed it to the higher rate. Now, of course, obviously, there's a distinction between the doctor's liability and Martin Gottlieb's liability and then the other defendant's liability. But I think, I mean, hypothetically speaking, if there was any physician signature in the template complete box marked and there was nothing at all in the attending physician box, we haven't seen any cases. For instance, because the motions to dismiss were granted against these other defendants, we've not got to do discovery for any other records to see if that ever actually happened in this case. We don't know if that happened in this case and what would have been the result. But I do agree that hypothetically speaking, Martin Gottlieb and Associates could have just went ahead and submitted it at the nurse practitioner's signature and her national provider number, and then it would have been billed. But they went ahead and he added in Dr. Michael Boyko as being the physician, regularly scheduled physician, put in his national provider number when he was not even scheduled to work that day, period. And it was billed at the full rate.
I don't want to get stuck in this, but that sort of confused me too, because it kind of sounded like the reason this was upbilled based on your own allegations had to do with which doctor's code number or ID number was involved and had nothing to do with anything on this form.
No, and that assigns exactly what happened with Martin Gottlieb submitting the final bill. I mean, obviously, under the False Claims Act, you can have the records. You can have false records which are material to a false claim that's sent in for payment.
Doesn't the Q6 code tell us that Boyko is not the doctor? I mean, what else does the Q6 code tell us?
No, it would tell you that. It would tell you that there was a locum tenens physician substituting for that doctor. But normally the way
so an intelligent reader of the bill that's submitted would say, yes, this is Boyko's number, but Q6 tell us that Boyko is not the doctor and it was somebody else. Right? So all of that is known to whoever's getting the bill.
Except that he was not a regularly scheduled physician for that day. He was never scheduled to work on that day. But I understand what Your Honor is saying. I mean, the Q6 does indicate that there was a locum tenens physician substituting for a physician. But it just so happened that Boyko was never scheduled to work that day and called in sick, and they needed somebody to substitute for him.
Well, let's hear from your opposing counsel. You have some time in rebuttal to continue this.
May it please the court, Brian Roark here on behalf of 7 of the 8 defendants appellees. I'm here on behalf of Dr. Perney, Dr. Boyko, the Best Practices entities, Holiday Acquisition Corp, MCare, and Envision. To pick up on the questions that the court had focused on the summary judgment ruling in this case, it's important for the court to appreciate the procedural posture and how we got to this point. The relator in the case is not a corporate insider or someone who worked at the company. The relator is a patient. She was treated at the hospital in 2012. She initially filed a medical malpractice lawsuit in state court.
So sorry, not to cut off your procedural background, but can you answer the inverse, I think, of the question that I asked your colleague? So Perini says, nope, didn't do it, right? Wasn't me. And arguably supports that by saying in his deposition, look, the check marks look different even, right? Like it's not just me saying it. I've got some objective evidence of that. But why, help me understand why I wouldn't piece together, sort of maybe 3 things, maybe only one of which matters. One, that it is completed when the time it's submitted, which means somebody did it. to Gottlieb, who is the other person in the chain that, not person, literally, but the other link in the chain says, I just rely on the forms to create the bill, right? Which maybe you imply from that he didn't do it. Maybe there's an implication there. And then third, and maybe weakest, I mean, it is signed by Dr. Perini. So why don't those three things do enough to create, and anything else your counsel said that you think's pertinent to it, but in particular, those three things, to create a material issue of fact on that issue?
The only claim that's brought against Dr. Perney is an A1B claim under the False Claims Act. The relator didn't bring an A1A submission of false claim. They alleged that Dr. Perney made a false statement. And so to your question, the district court dismissed the entire case, but let the case go forward as to just Dr. Perney on this one issue of whether he made a false statement. We offered Dr. Perney's declaration. The relator chose not to depose Dr. Perney in the case. And so to hear the argument that this is a credibility issue, the relator had every opportunity to develop evidence, put Dr. Perney back
The deposition we're reading is from the state court action?
It's from the state court action that in the state court, the relator brought a billing fraud claim as well, did depose Dr. Perney in that case. The state court granted summary judgment to the defendants that billing fraud had not been established. To your question, as it relates to Dr. Perney, the testimony, what's in the record is he said that he reviewed the chart and he signed it. He signed it at 6 a.m. Ms. Taylor had been discharged at 4 a.m. So I think it's important and it's relevant. He didn't backdate it. He didn't say that he had seen her at 3 a.m. He reviewed the chart, which the testimony in the case was it was routine and commonplace for physicians to review the charts of extenders. Even the relator's expert agreed that there's nothing out of the ordinary, that doctors routinely review charts of nurse practitioners for licensure, for just that it's a good practice to see if they agree with the care. And so from the evidence that's before the court, there isn't evidence about who filled out the attending note box other than Dr. Perney testified that he did not do it. And there's no evidence that contradicts that.
So what do I do with the testimony that maybe it's a declaration from an employee at Gottlieb, I can't remember the name at the moment, who says in general, not specific to this form, in general, we, the company, relies on these forms to prepare the bill?
I don't think that could tie back to liability with respect to Dr. Perney. Dr. Perney doesn't get paid more or less depending on how this particular claim is billed. His testimony was he was not involved in billing. He didn't know anything about how the claims were being billed. I understand what the court is saying is, well, but look at how it did get billed. If this claim was billed incorrectly or billed in error, that doesn't establish False Claims Act liability with respect to Dr. Perney or any of the other defendants as well. The outcome of this case doesn't rise and fall on whether the claim was billed correctly or not. It rises and falls on, as to the other defendants, have facts been pled that show fraud with respect to those defendants. And for Dr. Perney, it would rise and fall on what testimony and evidence was developed in discovery in the case. Plaintiff's counsel said, well, there could have been handwriting experts. The fact of the matter is there weren't. This is the record that we have before us.
I just want one follow-up question on the attending box. I thought, but I may be misremembering, that the district court also thought whoever filled it in, it's also not a false statement. It circles NP. It would be weird if the point were to try to trick someone into thinking this patient was seen by a physician to circle NP for a nurse practitioner. So the whole thing is too ambiguous at best to be a false statement anyway, regardless of whether Dr. Penry filled in the box or Perney, sorry. Am I remembering right? Is that what the district court said? And do you agree?
You are, Your Honor, and not surprisingly, we do agree. It is simply too ambiguous to try to define.
So why is NP possessive then? when it says NP's history reviewed, why would we think that it would be a possessive NP who was taking action?
It could be.
Have you ever written a subject like that in a sentence that was possessive? I mean, it's sort of an odd, I mean, it'd be extremely odd way to write a sentence, right?
Right. I can't answer the question because I have to speculate to do it. I really don't know. And at the end of the day, it's not alleged. And then there was not proof on why was the box set up this particular way? How was it routinely used? How did Dr. Perney use it in this particular instance?
About the certificate of authorization, it looks like to me the state law says it's unlawful for you to practice during that time period, and it did. Speak to that from the material requirement aspect.
The underlying facts are that best practices of West Virginia did properly enroll and was properly incorporated. It's supposed to file an annual report and pay a $25 annual fee. It did not. There's not facts as to why they didn't, presumably some type of oversight. They didn't, and then automatically under West Virginia state law, you don't file your annual report, you don't pay your fee, your license is revoked. That also had the effect under West Virginia state law, as it's alleged in the complaint, of nullifying best practices of West Virginia's medical corporation certificate of authorization. Accepting those facts is true. The two problems here are that there's not materiality and there's not scienter that's been pled as to either defendant. On materiality, you can go down the line of all the factors that are laid out in the Escobar case. This doesn't go to the heart of the matter.
Would it matter? Do you agree, I assume, that if their license was suspended for Medicaid fraud, right? So if the HHS, either at the state or federal level, suspended their license for Medicaid fraud, that license suspension would be material?
Yeah, in all likelihood, yes. The circumstances matter. If they had presented false information on their application, if the application had been terminated because one of the underlying physician shareholders lost their license to practice medicine, this is no different than a general business license that a taco truck or a soda shop has to have in order, if someone wants to operate under the corporate form as opposed to being a sole proprietor. This is the certificate of authorization that's necessary under West Virginia law. The fact that it was terminated or revoked for non-payment of a fee doesn't relate to whether the services that were provided to Ms. Taylor came from a qualified individual who was able to do that or not. And it stands in stark contrast to both the Escobar case itself, to Triple Canopy, to any other materiality case that we've reviewed or cited in our papers. This comes down to what were the facts alleged that support materiality. The argument, as we understand it from the relators, is more of, well, they did lose their business license, ergo, we should be able to go forward into discovery. And this court held in the U.S. XRL Complin case, the mere fact of a regulatory violation is not enough in and of itself.
Can you address just a second, at least the Gottlieb dismissal with respect to the high severity, just the narrow piece? Right? Because it seems, at least taking the allegations at the motion to dismiss stage for this claim, that they allege that this cellulitis is not high severity, that the medical records showed that. I take them at their word at that, and that then Gottlieb billed it as a high severity. And so it seems like, based on the allegations there, that they've alleged that that was false. Can you tell me why it was appropriate to grant a motion to dismiss, given that it seems the record establishes falsity, maybe not some other things?
Yes, Your Honor. And I'll note my co-counsel represents Gottlieb. So
I'm sorry. Is he coming up in a minute?
He is.
Then save it for him. Don't answer for him. I'd rather him answer.
Not answering for him. The same claim is brought with respect to the other defendants. I would agree that they adequately alleged that the claim that was submitted was not correct. They adequately allege facts saying it should have been billed at a lower level. They do not allege facts showing that that was false. There's a difference under the False Claims Act. If you're going to impose the punitive damages that come from that, it's not enough simply to allege in a case that, well, this was billed at a 99285, it should have been 99284. You have to couple that with what did the defendants know? Was there some pattern or practice? Or even in this particular case, what are the facts showing that someone either knew actually or should have known that this claim was not billed at the correct level?
In other words, based on the complaint, it could be negligent, it could be reckless, or it could be fraudulent, but we can't tell. And if it's just negligent, that's not enough. I mean, they just could have made a mistake, right?
It could have made a mistake, and I would disagree that it could have been reckless. It could have been fraudulent. There aren't any facts alleged showing that. If we accept that the claim for Ms. Taylor was not billed at the correct level, there are no additional allegations relating to the code that was provided. Again, typically these cases are being brought by corporate insiders who'd worked, and so maybe you'd have testimony from employees who talk about, we were pressured to bill things at a higher level than actually happened, or testimony about the company looked at reports and they monitored trends on what levels of code should have been pled. We don't have that here. What we have here instead is we're not necessarily into Charles Dickens' Bleak House territory yet, but we're moving in that direction. This case has evolved in numerous fashions over the years. And as Judge Berger, we would submit, rightly found, the plaintiff has not done anything to parlay their med-mal lawsuit and claims into a lawsuit under the False Claims Act, either based on expiration of a business license or based on alleging some type of scheme to upcode claims. The last thing I want to address, one of the other questions that went to Relators Counsel. The Relators Counsel argued that if you look at the complaint, that there are facts alleged in the complaint that Dr. Kitchens told Dr. Perney or others to sign off on the charts for patients that were seen by mid-levels in order to bill at a higher level. That is correct, with the exception of if this is in paragraph 167 of the complaint, what Dr. Kitchens allegedly told Dr. Perney is, yes, you need to sign off on charts seen by mid-levels. The complaint doesn't allege that was that what he told Dr. Perney was to do that so that the claim could be billed at a higher level. And the court below rightly found that the relator didn't satisfy pleading false claims, presentment of false claims, but also didn't plead a scheme. There's no allegation about a scheme to submit false claims. And based on that, we would ask that the decision from the trial court be affirmed. I'm happy to answer any additional questions, or if not, we'll turn it over to Gottlieb's counsel.
Thank you very much. We'll hear from your co-counsel.
Good afternoon, Your Honors. My name is Robert Williams. I'm a lawyer from Tampa, Florida, representing Gottlieb in this case, as you know. To address the question, Your Honor, that you posed to Mr. Rourke, let me adopt his answer in full. He did a very good job. One has to put this in perspective because Gottlieb was dismissed based on a motion to dismiss at the pleading level. And the trial court, I thought, did a spectacular job of going through a rather voluminous complaint, multiple allegations of all kinds of things, and distilling it down to a simplistic analysis that you can't just allege these things generally and hope that through discovery you can fill in the blanks. Now, in a false claims case, particularly with 9B at stake, you've got to fill in those blanks in the pleadings themselves, the who, what, when, where, and why. In the perspective of Gottlieb, Gottlieb is not on the inside. It's a biller. It's a processor. It receives the records, as Your Honor said, and the person from Gottlieb apparently testified, and we take those records as they are, and we distill them into a bill, and we send the bill on to Medicare or Medicaid or to a private processor or a payer, if the case may be. And what the relator is suggesting is that Gottlieb should peel the onion and distill from all of these records what the relator says is the underlying fraudulent truth, when in fact that is not the way it works, and they know that's not the way it works. And they're hoping, if they can get back into court, to figure out some way to prove this. We have to remember that in these false claims cases, in order to file the case in the first place, you have to submit a statement to the government, usually to the local U.S. Attorney's Office. And they determine whether they're going to intervene or not. And that statement, as Your Honors know, is filed within sometimes the day before, sometimes the week before you file your own complaint under seal. In this case, the government chose not to intervene. Now, I acknowledge that the fact that the government chose not to intervene in and of itself doesn't suggest that there's not a good case. I'm not going to take that argument, the inverse of what Justice Thomas said in the Escobar case. But in this case, it does have some, I think, heightened materiality from the point of view of this argument, in that this, as counsel said, is not your normal false claims case. Usually that's from an insider who, in my experience at least, has assembled and marshaled a lot of facts along the way so that they can present to the government the facts that will tell the who, what, when, where, and why, and allow the government to make their own assessment based on those detailed facts. Here, that's not the case at all. The relator is an outsider. She's a patient, and she's only one patient.
So you represent Gottlieb, so let me ask the question on Gottlieb.
Yes, sir.
Gottlieb claims that it relies on the patient medical record to code the condition. Yet here, when we look at Taylor's record, it reveals a diagnosis of cellulitis. While she was coded for something totally different, an immediate, significant threat of life, I think we all agree that general definition of cellulitis doesn't fit there. So how is that sufficient? I mean, how is that not sufficient to establish a false claim that's being?
There were no, excuse me, Your Honor.
Yes.
There were no facts, not conclusions, not general assertions, but facts that supported that Gottlieb or the human being at Gottlieb would be able to discern that from those medical records. It was signed by a doctor. There was a dialogue here with relators counsel.
Made it an immediate life-threatening situation, even when you look at what the doctor signed. Looks like to me it says cellulitis.
It would expect the person who is actually looking at that to try to read between the lines to determine exactly what the doctor is doing here. When the doctor signs off on it, I think it's fair to say, and it's reasonable to assume that a person that looks at the records as a whole is not in a position to determine exactly if there's some underlying meaning here. The billing processor is not a position.
I'm not following that, and I don't want to take too long here, but if I go to the doctor and I sprain an ankle, and it says he sprained his ankle, and it shows up at Gottlieb, and Gottlieb says, a sprained ankle, we're going to code that as life-threatening. That would be, incorrect, right?
On the face of Your Honor's question, right. Yes.
And so I took Judge Wynn's question to be, that's also true for cellulitis. It like an ankle sprain is not life-threatening, and yet your client coded it as being life-threatening.
Because it was signed by the physician. And
Wait, I don't understand. Is everything signed by a physician coded as life-threatening?
No, of course not. I don't
understand why was cellulitis signed by a physician coded as life-threatening?
Well, I can't answer that question from a factual point of view, Your Honor. What I can say is that what they're trying to take is this discrete episode and manufacture it into a fraudulent scheme. And what the trial court determined was they didn't allege enough facts to support these conclusory allegations as to materiality and as to scienter and to this entire upcoding scheme, as they would suggest, this one episode can be translated to 25,000 patients, the names of which we don't even know at this stage. And that's what Judge Berger did.
Time has expired, so thank you very much for your argument here. We'll hear from Mr. Monahan as to have a little time for rebuttal here.
Thank you, Your Honor. Just going back briefly, I have the note, for instance, here, the language that we discussed about the attending physician's note in the signature line. I would note in regard to some of the prior questions, though, there's no signature inside the attending physician note for another signature. If you have one physician that just reviews like the nurse practitioner's treatment, and that signature line is only for that, there's nothing inside if there's an attending physician to sign in there. There's only one signature line. And one of the things our experts said is the way this is filled out by these people leads to it being incomplete or confusing and enabling Martin Gottlieb and those to do the upcoding, because it doesn't specialize what happened and what the physician did. Did the physician merely, like for instance, the only thing about checking, looking at the plan is in the attending physician note. There's nothing down below where the physician's signature is for a line that says review chart or reviewed. So, I mean, the form itself is confusing the way these people are instructed to fill it out.
I guess I sort of had the same question, but I thought maybe it cut in a different direction. I didn't see anything in even if we assume for a second that Dr. Can I remember his name? Dr. Perney? Henry Perney filled out the attending box. I'm still not clear on what in the box is false, because you're right, it doesn't say a doctor did this.
Okay. Well, I mean, because the attending physician, if you look at it's marked, the first check mark has resident, and then as Judge Richardson pointed out, it has the NP possessive,
right,
history reviewed, but then it also says patient interviewed and examined.
So you think the check mark on the first line means that this was done by a resident or a PA?
Yeah, well, I think what it means with it being checked like that is it's an indication that the nurse practitioners, the history was reviewed that the nurse practitioner took, but that the doctor himself or herself actually interviewed the patient and examined the patient. And that's one of the things about this form that our experts.
I don't want to. Who, as you look at this box with that check mark indicates that a resident, that a particular doctor reviewed the nurse practitioner's history, yeah, or that some doctor, and you get that because resident / PA means doctor.
Yeah, well, the resident does, and then, but because of the attending filled it out, and then the physician signed. I mean, according to our expert, that itself it indicates that the physician was the attending and actually did the exam and looked at all this.
Okay, so it's not what's in the box so much; it's the signature underneath the box that indicates that the doctor did the things in the box.
Right, because if it was
what's in the box is false.
Well, I mean,
okay.
I would argue that it's all important or all has relevance, but you're right that the signature line, because if they permitted the nurse practitioner just to technically be the attendant, all you would have is her signature, which is actually up above there in the record, and they call it the T sheet. It's up above there.
Right. The line right above is for the resident PA or NP to sign, right? So that's who's done all the work so far. And then the box below that, where it says attending note, physician signature, and template, is the doctor's piece.
Right.
And the doctor either checks that I've reviewed whichever one of those three signed on the line above, I've reviewed their history, I interviewed the patient and I examined them, or they leave it blank, indicating that they did not do that.
Correct. But I want to try to cover a couple of the other things here quickly.
What do you mean correct? You mean if you leave it blank, then that's okay to say he didn't do it? Because isn't that your allegation that he made a false statement, but you think he actually did fill it out? And he said he did leave it blank.
We have alleged, or we believe he did fill it out, and it's certainly a reasonable inference that he did fill it out.
The only evidence is he didn't fill it out.
Well, that's his testimony, but that's self-serving without any other cooperative evidence. That's not really enough to grant summary judgment. And they only, I guess Judge Richardson thought maybe the check mark looked different, so that was cooperative evidence. And I would disagree with that part.
I feel like maybe I'm missing it, but feel free to explain it to me. So this would go to a jury, and a reasonable jury, I guess the theory is he would come and testify and say, I didn't fill out the box. And then your client would say, well, I think you did. And then a reasonable jury could find that he did.
Yeah,
in the absence of any evidence that he did. I mean, I guess that may be right. Maybe they would just think he was a big liar and discredit everything he said.
Well, going back to like Anderson versus Liberty Lobby, one of the Supreme Court's trilogy of summary judgment cases, not only are reasonable inferences something the jury can determine, but also credibility. And sometimes you got to look at a person face to face and see them on the stand as to whether or not you choose to believe them, whether or not you find them credible. So yes, I would think, but I do want to, I know I'm past my time. If I could discuss the false certification claim somewhat, I wasn't permitted.
We're going to conclude here at this point. And want to thank all of you for your wonderful arguments. Normally, as I said, we'd come down and shake your hands, as is our tradition. We'd love to do that, but we're not going to put you at rest, nor let you put us at rest for a virus. But there will come a time when we will do so again. Thank you all for your time.
Thank you, Your Honor.
I'm ready.
Well, it appears as though we're COVID ready, so let's proceed by hearing from the appellant in this case.
Thank you, Your Honor. May it please the court. My name is Craig Hensel. I'm here on behalf of appellant Daniel Biddle Lindsay. We are here today to ask the court to recognize what the defendants themselves have already recognized, that Seegers is a single company.
I think it's okay for you to remove that mask from that distance here unless you are uncomfortable doing so.
Sounds reasonable to me, Your Honor. We're asking the court to recognize that Seegers is a single company with multiple alter egos. Seegers itself recognizes this. It admits it in its marketing materials, on its website, its employee handbook, and even in its own internal discussions.
Counsel, I'm sorry to interrupt, but just so I understand where we're going, this is your only claim. You are not arguing that Seegers Newport alone has more than 15 employees?
Your Honor, we do believe that is a facted issue, but we don't believe it's our strongest claim. We will be going forward on the pierce the veil theory of liability here today.
That's the only claim you want us to consider.
Yes, Your Honor.
Okay.
The only time that Seegers denies that it's a single company, in fact, is actually now, when doing so might render it liable. We're here on appeal of a granted motion for summary judgment. Standard review is de novo. And briefly give the background. Mr. Biddle Lindsay was an employee for Seegers Fence Company, Inc. of Newport.
We can go directly to the issue that you're bringing us. You say you don't rely on Newport as having 15 employees. So the basis that you argue is that we ought to pierce this corporate veil and that use all these employees or part of them to exceed the 15 so you can be able to proceed.
Oh, yes, Your Honor.
We kind of have the facts down.
Okay. So for smaller employers with less than 15 employees, there have been multiple ways recognized of those employers still being liable under laws with a 15 employee threshold. The Papa v. Katie Industry case lays out several of those, and they're also recognized in.
Can I ask you, this sort of goes to my first question. I really am trying to get my hands around what it is you are arguing. The Papa case does talk about different ways you might get over 15, but only one of them is piercing the corporate veil. And I thought that was the only one you want us to consider, right?
In brief, Your Honor, we do talk about the excessive fragmentation issue as well.
And did you raise that as a separate claim before the district court, or did you just tell the district court pierce the corporate veil?
We have not precluded ourselves from that argument, Your Honor. It's not a specific cause of action, but that is this is a de novo. This is a de novo hearing.
You say you haven't, but you need to be more specific in answering that question. I read it the same way. I thought the issue here is on piercing the corporate veil. I didn't know we were considering other instances in which less than 15 would be there, because it didn't seem as though that's properly raised.
I mean, this is the hearing here is de novo, Your Honor. We haven't.
Counsel, it is de novo, but I think there is just some confusion here. The court in Papa is talking about two different things. One is maybe you can pierce the corporate veil. The other is you absolutely cannot pierce the corporate veil, but under whatever it's called, in terms of to define employer for some of these civil rights statutes, even when you can't pierce the corporate veil, that's off the table. There are circumstances under which we will allow for aggregation of the number of employees across entirely separate corporations. But I didn't understand that you raised that separate theory before the district court. I thought you only asked the district court to pierce the corporate veil.
We did not, Your Honor.
You also said even if you don't pierce the corporate veil, we nevertheless should win on this separate theory.
We did, Your Honor. And issue preclusion has never been argued on that part by defense counsel.
It's not really issue preclusion. It's more just that you can't come to us with a theory that you didn't present to the district court.
That's true. And opposing counsel raised that as an argument against our whether Seegers Newport has 15 employees. Our argument on that factual issue. They haven't raised it as an argument that we didn't raise the excessive fragmentation issue in front of the district court. That was an argument brought before the district court. And
I thought before the district court, you argued excessive fragmentation might be a reason to pierce the corporate veil.
It's both an element and on its own. We argue that it's both an element and on its own a separate cause.
Can you address the Johnson decision from our court where we talk about when you can aggregate employees in a parent subsidiary relationship, and we say that you cannot do it merely because they're the parent. And then it goes on to say a parent company is the employer of a subsidiary's personnel only if it controls the employment decision, right? So it's the decision maker, or you can pierce the veil is the second. So it gives those two options. It doesn't include this third possibility, this excessive fragmentation possibility. Why isn't that only in that phrase suggestive that resolves our question? We don't have an excessive fragmentation theory in the Fourth Circuit.
I don't know if that case, Your Honor, was relying on its understanding of precedent or whether that was actually on its own saying that those are the only two reasons. Going off of precedent, there is.
Well, no, I mean, that's the holding of the case, right? So it is an ADEA case, right? So It's a different statute, but the same question, right, is about how many employees it's got. And that's what I take. Maybe you tell me that's not the holding, but I take it to be, the parent is only if it controls. Now, maybe if it's not a parent, and maybe you want to say this isn't a parent subsidiary, but I take it otherwise you're arguing that it is. And so
this is absolutely not a parent subsidiary relationship, Your Honor. The defendants will be the first to admit, perhaps even argue, that these companies are not parent subsidiary. They are not. They're not franchisor relationships. They don't have any kind of contractual relationship in that regard. And so that in fact is pretty crucial to our argument here, because our argument is that lack of contractual relationship is part of the piercing the veil issue to begin with, because the contractual relationship allows them to deal with each other at arm's length. But when it comes to the excessive fragmentation issue,
but if they have no I'm not sure I understand that. If they have no contractual relationship, how do we even get to I think they do have a contractual relationship, but how do we then get to piercing the veil? I mean, we think about piercing the veil in the context when there's they are interrelated.
And they're significantly interrelated here, Your Honor. It's the contractual relationship between a well-organized subsidiary parent relationship or a franchise or franchisee relationship that has both companies working in their own independent interests. That has them dealing with each other at arm's length. Here, they don't have such a contract that defines their duties and obligations and rights with regard to the relationship between each other. They're not going to be dealing with each other at arm's length, but they're inexorably interconnected. They have shared ownership. The Seegers, Batchelor and Rouse families, primarily the Seegers family.
So some of the shareholders overlap is what you mean by shared ownership?
Not just some of the shareholders, Your Honor. The majority shareholders, or at least 50% shareholders in every single Seegers entity, are a member of the Seegers or the Batchelor family or some combination thereof. It is significant overlap in ownership. The three executives of Seegers Corporate, and whose names escape me right now, but the three executives of Seegers Corporate stand as president or vice president of every single Seegers entity. And I should say that I'm not just making up that phrase Seegers Corporate to make it sound like a company. That's a phrase they use, as are branches, which is what they refer to every other Seegers entity as. They call themselves corporate. They call themselves branch entities. They are themselves recognizing that it's a single company, Your Honor. If I could get back to the excessive fragmentation issue that was raised earlier, the parent subsidiary relationship is not particularly subject to excessive fragmentation because excessive fragmentation is a single enterprise that is split into multiple corporations. A parent subsidiary relationship is kind of by default split and by necessity, given that organization, multiple corporations. It wouldn't really be an excessive fragmentation. Excessive fragmentation wouldn't really be a concern in the parent subsidiary relationship.
But doesn't it, at least under the Papa case, it's not just excessive fragmentation at a broad level. It's excessive fragmentation, quote, for the express purpose of avoiding liability under the discrimination laws. Right? There might be the scenario where someone did it for the purpose of avoiding discrimination laws, that we might combine them as an employer. But what is the evidence here that the purpose of any fragmentation that's here had anything to do with the ADA?
We're never going to, in fact, cases are almost never going to get direct evidence of that, Your Honor. The purpose is going to be kind of inferred through indirect evidence.
Right, but I think what cases like Papa have in mind is like you have a 140-person corporation and you decide, you know what, I'm just going to break myself into 10 corporations of 14 each. Then you might infer from that oh, you're probably trying to avoid the 15-person minimum under the civil rights statutes. Where's that evidence?
Well, what we have here is a 276-person corporation who opens a new corporation each time they open a new office. The offices themselves are kept small. The Newport office, for example, has 13 employees, just under the statutory minimum.
What about the others?
Well,
Is that in the record anywhere?
that is not in the record,
Then I
except for
don't
the
see
fact
how
that
you-
Seegers Corporate is slightly over that limit.
Mhm.
And they're all, I mean, they're in different geographic areas, right?
They are.
I mean, so there is an obvious reason why they have a different corporate form in each area, because they're not the same ownership, right? There's overlapping ownership, but they're not the same ownership. And they're in different geographic areas. So it would be odd not to be separate entities here, wouldn't it?
It would not be odd not to be separate entities. Pretty much any company that is national, multinational, even state level has multiple locations, multiple areas in which they operate, and yet is.
But the same ownership, right? In that scenario, that posits a situation where there's the same ownership. Here, they don't have the same ownership.
That's true, Your Honor. And at the same time, if one were to, they may have broader ownership. One would have the same effective result by having a single corporation with the same owners as you see in the split entities, just kind of merged together with equivalent stakes in the overall corporation. They have opened a new location or a new corporation every single time they open a new location. That said, even with or without the excessive fragmentation issue, we still argue that we were able to pierce the corporate veil, which is a valid test here. I believe defense argument for the entire brief was focused on the integrated employer test, which is a separate test from piercing the corporate veil. Piercing the corporate veil, if we include excessive fragmentation as an element, we meet 9 of the 13 elements. If we don't, we meet 8 of the 12 elements. The elements we meet.
What is the best support in the, I mean, piercing the corporate veil is sort of an established doctrine, right? I mean, we see that in lots of different areas. Is there any other context in which we have as an element excessive fragmentation in the piercing the veil context?
Not that I'm aware of, Your Honor. That said, these are companies, as I said, that fail to deal with each other at arm's length. They seem to see themselves as a single entity. They put themselves forward as such intentionally to mislead consumers and prospective employees. Your Honor, we're simply asking the court.
Why would they do that? I mean, why would you want to mislead consumers? I thought the purpose was you set up these different entities. You put someone like Mr. Ruick, who's a manager, 50% interest, you incentivizes him. I thought it was, well, in Goldsboro, North Carolina, I was impressed. You got all these different companies that come out from it, and you've got ownership not primarily by the seeker people in it. And I think the central issue here has to do with the labor control issue here. And as I understand, Mr. Rook is the one who actually does all of that labor relations within it. And so the reason, I don't know if you indicate is to deceive customers or consumers, but I don't understand the purpose of doing so when it seems clear that there is a purpose of incentivizing someone to really take ownership of the company and sell some fences.
I understand. Your Honor, I appear to have gone. May I answer the question?
Just
thank you. So the Seegers itself, in its 30B6 deposition, admitted that the reason it had its companies on its website, it aggregated its number of employees, that it aggregated its inventory for all the companies, that it referred to the company as our company, that every indication on its website seems to show that all of these Seegers entities are a single company. Seegers itself admitted that was to instill consumer confidence in a brand that has been around since 1949, which that 1949 year only applies to Seegers corporate. It does not apply to the branch entities. If they are indeed separate companies, that is not a brand that has been around since 1949. The aggregation, the appearance of these being a single company that is intentionally put forward by Seegers is specifically on the consumer side to instill consumer confidence in the overall brand.
All right, Mr. Henson, let's hear from your opposing counsel, and then you have the fortune of having additional time to rebut.
Thank you, Your Honor.
Okay.
May it please the court. My name is Katie Hartzog, and I represent the defendants in this matter, Seegers Corporation and Seegers of Newport. I'd like to first just start off by clearing up some of the questions that you've already asked and the issues that have already been raised. So how these corporations work together, they are indeed completely separate corporations. Is Seegers Corporate, which is in Goldsboro, North Carolina, serves the administrative.
You're representing both of them.
I
You're
am
representing
both of them.
that one and the other one, and I take it there's no conflict in doing so. Because if I guess the outcome would be if the plaintiff prevailed, I guess Newport would be on the hook, or I don't quite understand what the outcome would be. But I'm just it's curious is you say they're separate, but they have one counsel.
They are separate, and I am representing both of them because they do not have a conflict of interest between the two of them, because everyone is in agreement about how these businesses work together.
I'm not saying they should. I just thought it's interested in usually when you have separate entities and one is saying, and maybe the entities aren't disagreeing in terms of what they are saying the situation, but the other side is saying they are one thing and you say you're not, but the two of you agree, at least the two corporations agree of what they are. So you can proceed. I just threw you off a little bit there.
And well, I might get into that right now, because what Seegers Corporation does is handle a lot of the administrative functions for the branches. So they handle the website, they handle insurance negotiations, they would hire an attorney if one needed to be hired to give advice to someone. I mean, they do all of those administrative things for the branches. What the branches do is sell fences and install fences. And so the whole business model here is that to allow the branches to focus on what the branches do best, which is sell fences and install fences, they want to take these administrative functions off the branches and allow them to focus on what they really do. Meanwhile, Seegers Corporate
am I fair in sort of thinking about this as like it's a homegrown franchise, right? I mean, you're not using franchise law, but you've just created sort of a franchise situation where you've got a corporate, and corporate's got some ownership interest in each of its branches. But as Judge Wynn pointed out, each of the branches is really owned by somebody who's got the incentive to, sell as many fences as they can sell. And you haven't used a technical franchise law, but this is sort of a homegrown version of one drawn up on a napkin.
It is. And there's no doubt that there's interrelationship between these companies, that they support one another, but they are totally separate, distinct companies. And the law says. Each one
is incorporated separately. Is that right?
I'm sorry.
Each one of those branches that you call them incorporated.
They're all incorporated separately. And the business model behind that is that they have different business partners who are in those locations, who are in those markets, dealing with the customers in that area. And just like you said, they want to give these people in this market the incentive to do well. And so if they do well, they make money. If they don't do well, they lose money. They want them to have skin in the game. And that's the whole business model here. And that's why they are incorporated separately, to allow that to happen. If it were one big, huge company, then, for example, Newport might have expenses for a lawyer right now. Well, that expense would be borne out by every other branch in the organization. The way it's set up is Newport bears that expense alone. Meanwhile, if another branch does really well one year and sells $3 million worth of fences, then they keep the profit from that. So it really incentivizes these different branches to do well and to succeed.
So is this corporate structure here something, I'm racking my brain trying to think, have I seen something looks like this? That's not a franchise. It's not a franchise per se, because you didn't follow the law. It's not just totally separate in it, because there is some interconnectivity there somewhere. It's an interesting structure. I Actually, I was curious about it when I saw it. And I don't know if your law firm actually set it up or.
My law firm did not set it up, but a lawyer did help with it. It was not us, but
Pretty sure of that.
there is certainly members of the Seegers corporate part of this that have ownership stakes in the branches. They invest in these companies. And that is exactly why this corporate structure is set up like this, so that they can avoid liability if, for example, one branch fails. That's the whole reason they're set up separately.
Can I ask you a question? A big part of your colleague's presentation is about how Seegers holds itself out to the public for marketing purposes as one entity. How does that factor into the veil piercing analysis in your view?
I actually disagree with that, because what he's talking about is the website and everything that's on the website. And if you were to log on to that website from a certain location, based on where you log on, where you are physically, it would take you to the landing page for the branch that's in your area or closest to your area. And the website actually lays out each of the individual branches have a separate page. And on that page, it tells who the owner and manager of that branch is.
Well, what if, I'll just make the question purely hypothetical. What role does public facing marketing play in the piercing the corporate veil analysis?
I don't think it plays any part of it at all, because we cited to a couple cases in our brief where courts have looked at this, and I couldn't find any in the Fourth Circuit. These are actually California cases, federal court cases out in California, where this issue is addressed. And they said that a website is just an administrative function of a business. And it's not unusual in this business climate that we're all in these days for businesses to share that expense. And one of the courts looked at it and said, as long as it's clear that different locations are owned by different entities, and here it is, because our website specifically lays out that different owners own these branches, then there's no issue.
So you used the word branches, and I can't help but just figurative, at least in terms of conceptualize it, I'm thinking of a tree that's tied into with branches out. There's something center holding it, and it's this corporation. And I'm wondering, why don't you say affiliates or something that is not so connected to it? Because a branch is intimately connected with that trunk there. And if it's not connected, it dies.
I don't mean for it to be a term of art in any sense. I use the term branch because that's what's in the record. That's what the Seegers representative called it. He also calls these people who own these different entities, he calls them business partners, because in essence, they are in business together. They have entered into these relationships.
I don't think it controls it. I'm just saying figuratively, that's in my head when you use that term. And you may continue, but I'm just pointing out. So
I understand. And the reason why I use it is because that's what's in the record. And I feel like that's what I have to call it, since that's how it's described in the record, or how it's portrayed in the record.
So of those things, those elements that form that integrated employer test, do you agree that is the centralized control of the labor relations that's probably the one that you would weigh the heaviest?
Absolutely. And that's what the case law says, is that is the most important thing to look at, is who controls the employment relationship. And in this case, it is clear. Clint Rouse testified that he hires and fires all employees. The testimony from the Seegers corporate representative was that they have nothing to do with hiring and firing. They don't even know when employees are being hired and fired. They don't know that they're even looking to hire or fire anyone. They have nothing to do with payroll. They have nothing to do with the day-to-day management of the company. They have nothing to do with disciplinary decisions. I mean, there's just absolutely no control by Seegers Corporation over what happens day-to-day at the branches. So if we're looking at the integrated employer doctrine, it just does not apply here. You only can look at Newport, because Newport was the employer and Newport did not have 15 employees at any time.
And on the fragmentation theory of the integrated employer inquiry, is it your position that just that's wrong, or is your position that right or wrong, it just doesn't apply here?
Right or wrong, it does not apply here, because there's not excessive fragmentation, because these companies are set up completely separate, and it's because of the different markets and because of the different locations. That's the only reason why they're set up differently or they're set up separately. It's not done intentionally to harm anyone. It's not done intentionally to take away anyone's rights or to avoid compliance with any law that might otherwise apply. It's only done because of a market.
It's like a gerrymander theory. That's the way I read Papa, that it's, you're looking for sort of a splitting up into small things that wouldn't make any sense otherwise. Like that's not how you would draw the lines otherwise, but here it makes sense to have the separate brand.
Absolutely.
Separate affiliates, branches, whatever we want to call them. Okay.
Absolutely.
Remind me of this, please help me out. You have about 14 of these so-called branches?
That sounds right.
And do any of them have employees over 15?
It's not in the record, Your Honor, but they do. Yes. I mean, it makes sense. I mean, think about it. Newport, I'll look this up. Newport has a population of less than 4,500 people.
Where's Newport?
Newport is near the coast.
Oh, okay.
And so, they have branches in Greensboro and Raleigh and Charlotte and Greenville, North Carolina. These places have much larger population. They're going to build a lot more fences. They're going to need more employees. So the only reason why Newport doesn't have 15 employees is because the market is a lot smaller. There's a lot less fences to build and they don't need that many employees.
This is a bad set of facts. At least when I look at it, at least it raises some questions. I'm not saying it goes one way or the other. If you really got beyond this question as to what really happened here. But it seems to me to avoid at least coming under the ADA, you just don't have 15 employees in one of these entities here. Whereas you're telling me the others do. So this issue wouldn't be with regard to the others there.
If Mr. Biddle Lindsay worked for another organization, another branch somewhere else in a bigger market, we would probably be talking about the substance of.
So is there no redress to someone who's being put in the situation of Mr. Biddle here?
Well,
beyond, I suppose beyond the ADA is what I'm saying.
I suppose he could have other claims, but they weren't brought here. And, Congress made the decision for all of us.
State, I'll withdraw that.
Please, go ahead.
I just wonder if there's state law claims. I don't know whether does the state of North Carolina have discrimination claims?
Well, the state of North Carolina has a wrongful discharge in violation of public policy claim that can apply under certain circumstances. I don't know that it applies here, but there is a potential claim that could apply. But to answer your question, Judge Wynn, Congress set this up so that small employers who have less than 15 employees can focus on running their business and don't go under because of having to comply with federal regulations that might be very burdensome for them under certain circumstances.
They probably didn't have this scenario in mind, though. I'm not sure that it'd be this kind of connectivity with a major corporation, and then some branches would be covered and some wouldn't be. But I can't speculate what Congress would do, so we'll just move on.
I think that might be exactly what they had in mind, because despite the fact that Seegers of Newport got the benefit of having access to some resources through Seegers Corporate, it still wasn't enough to get them over the line to have enough business to have 15 employees.
All right. Do you have anything else you want to add here today?
Do you want me to talk about piercing the corporate veil? Because I'm totally prepared to go through all of these elements and tell you why they don't apply.
You need not do that. We have your briefs.
Okay. Well, I appreciate your time today. Thank you very much.
Thank you. Mr. Hensel, you have that rebuttal time I told you were fortunate to have.
Thank you, Your Honor. One of the earliest points brought up by opposing counsel, by the court and opposing counsel, was that this kind of looks like a franchise agreement, a quasi-franchise agreement drawn on the back of a napkin. If that was actually...
That's just South Carolina talk. You can go ahead.
Understood.
It's far fancier in North Carolina.
If that's actually what it was, Your Honor, we would have a much weaker case here, I believe. Franchise agreements hold parties responsible for things. A McDonald's franchisee uses the McDonald's, the logo, the millions of burgers sold or billions of burgers sold, whatever they're at now. They get to use all that McDonald's good advertising stuff. In exchange, they have to They have various obligations to McDonald's corporate. They have to pay rent on the land. They have to give a percentage of their sales. They have to use the exact same ingredients from the exact same suppliers, et cetera, et cetera. They're dealing with each other at arm's length. McDonald's gets something out of it. The franchise gets something out of it. Here, that arm's length dealing, the sense of there being two separate businesses, each working in their own interest, is not present. You have branches that sure work in their own interest, but they're aggregated under effectively a corporate structure. I mean, they call themselves corporate. They call themselves corporate and branches. And a corporate office that doesn't exist to make a profit. The corporate office exists exclusively to support the branches. Your Honor, that's not the way a company dealing with another company at arm's length, one that is looking out for its own interests, behaves. Additionally, the branches.
Don't they get paid a consulting fee for the work done to consult?
Yes, they do. And that is another problem because the president.
We don't want people that work to get paid. Why is that a problem?
Because how it works is that the president and vice president of each of the Seegers branches is one of those executives from Seegers corporate. They do not get paid by the branches for being the branch's president or vice president. They get paid by Seegers corporate for their role as president and vice president of a branch. Why would one company pay another company's executive, Your Honor? That's not working at arm's length. That's, in fact, intermingling of funds, which goes towards one of our elements. The fact that these presidents and vice presidents get paid a fee by corporate for consulting for other companies is an example of companies that are not working companies that are not working independently, that are not working in their own interest, that are not dealing with each other at arm's length. Your Honor, we believe our strongest theory here is piercing the corporate veil. We do believe that we should also win this on the excessive fragmentation issue, but I will point out that when it comes to piercing the corporate veil, defendants have not actually made an argument against that at this point. At this stage, defendants' entire argument seems to have been focused on the integrated employer test, which is an entirely separate thing from piercing the corporate veil.
Do you mean right here at argument?
I mean, in brief, I believe they focused pretty much entirely on the integrated employer test. They claimed that the UKIL case effectively took the teeth out of the Papa v. Katie case as it focused on the integrated employer test, when in fact that it did that because that was the test that had been put forward by the plaintiff in that case. UKIL actually, in fact, said that there are multiple ways of approaching this and cited Papa v. Katie with approval.
Can I ask you on piercing the corporate veil, I feel like we haven't talked much about this today. The district court, as I read the district court's opinion, the district court focused, at least in part and largely, on the second factor, sort of even assuming full control, alter ego, all of that. It doesn't matter because Seegers corporate isn't abusing the corporate form itself. It's not affirmatively using this corporate form to sort of commit wrongs. It's not hiding assets. It's not misleading creditors. The corporate form itself is not being leveraged to do bad acts. Why is that wrong?
Oh, that's wrong due to the Dassault Falcon case, Your Honor, which we cited in our brief. But the Dassault Falcon case basically said that and I see I've run out of time. Can I finish answering the question? The Dassault Falcon case, which we cited in our brief, says that if the corporate form is misused and therefore used as a liability shield, it is then the second and third elements for the piercing the corporate veil test, those elements being misuse and proximate cause of damage, those elements are presumptively met. And that's because the misuse element would be met by using essentially a fiction to defeat an equitable claim. The proximate cause element would be met by the plaintiff losing their ability to vindicate their rights due to that fiction. So we think the second and third elements are effectively presumed here because using the corporate form, this incorrect corporate form as a defense, it is the exact scenario contemplated in DeSalt Falcon.
But doesn't that sort of the second and third factors? I'm not sure. Well, it doesn't matter. Yeah. Okay.
All right. Well, thank you, Mr. Hensel. Thank you, Ms. Hartzog, and appreciate both of your arguments. As I've said to the other panels here, other lawyers, you know what we normally do. We come down and we shake your hand and thank you for you coming to visit with us today. I'll do so now because we'll not come down and do it in person, but there will come a time when we'll do again. So thank you and safe travels home. Court be adjourned until tomorrow morning.
Thank you.
Thank you.
This honorable court stands adjourned until tomorrow morning. Thus, the United States.